So the first category of fundamental right, this is a question which has been asked in the prelims examination. For example, a question can be asked in the prelims examination that abolition of untouchability falls under which category of fundamental right? Option A, they can give right to equality. Option B, they can give right to freedom. Option C, they can give right to what you can call freedom from exploitation. And option D, they can give right to conscience. Okay, the correct answer would be over here, the right to इक्वालिटी. तो इस तरह से थोड़ी सी चीज़ें हम एक बार रिवाइज कर लेंगे कि कौन सी राइट कौन सी कैटेगरी में आती है, कौन से हेड के नीचे आती है. तो फॉर एग्जांपल द फर्स्ट सेट ऑफ राइट्स विच आर गिवन फ्रॉम आर्टिकल 14 ऑनवर्ड्स आर आर्टिकल 14 इक्वालिटी बिफोर लॉ, विच इज ऑल्सो नोन एज द कॉन्सेप्ट ऑफ जनरल इक्वालिटी, राइट. अब इसको मैं बस बहुत जल्दी ही आपको प्रीलिम्स के बेसिस पे कौन से इंपॉर्टेंट कॉन्सेप्ट्स हैं उनसे थोड़ा सा रन थ्रू कर देता हूँ. कभी प्रीलिम्स में व्हाट वी आर नोटिसिंग इज फॉर अ वेरी लॉन्ग टाइम लॉट ऑफ कंसेप्चुअल क्वेश्चंस फ्रॉम द फंडामेंटल राइट्स पार्ट्स आर कमिंग. फॉर एग्जांपल लेट्स से एक क्वेश्चन आया था प्रीलिम्स में, आई थिंक इन वन ऑफ द ईयर्स 2019 और 2020, विच सेड दैट विच ऑफ द फॉलोइंग इज द बेस्ट डेफिनेशन ऑफ लिबर्टी, एंड दैट क्वेश्चन कॉज्ड अ लॉट ऑफ कंफ्यूजन इन द UPSC. So the civil services is causing a lot of conceptual questions out of the fundamental rights. So let me elaborate them one by one to get a sense of what we can achieve through this kind of a discussion. When we talk about, let's say for example, equality, which is given under Article 14, when we talk about equality which is given under Article 14, we talk about two concepts of equality. Okay, one concept of equality is known as equality before the law. Okay, this is one concept of equality, and then it talks about and equal protection of the law. ठीक है, तो अगर मान लीजिए ऐसा कोई प्रश्न आता है, there's a question which comes in the prelims examination as to which of the following categories or qualities of equalities are mentioned under the Constitution of India, what you have is two categories of equality: equality before the law under Article 14 and equal protection of the law. Okay, now basically the term which is used in terms of leading them to, in fact let's say for example I must substitute this not with and but or, which basically means that these are two very separate kind of equalities, and all I can say at this moment, for example, to give you a set of memorizing tips is that equality before the law is a concept which has been borrowed from the British Constitution, from the English Constitution. Right? It is a what you can call a concept which India has been inspired from the common law tradition, the English Constitution, equality before the law. Okay? And equal protection of the law is something that the Indian Constitution has taken from the American Constitution. तो इस तरह का आपका कोई प्रीलिम्स का एक क्वेश्चन बन सकता है कि equality before the law is inspired from which constitutional scheme? Because comparison of constitutions is a part of your main syllabus. Sometimes in the prelims examination, some questions can be asked with regard to the inspiration behind a certain conceptual idea. Equality before the law is taken from the English Constitution and equal protection of the law is taken from the American Constitution, right? And the Indian Constitution, in a way, inherits both of them. The question which was there before the Constituent Assembly was, should we follow the American model of equality or the English model of equality? And eventually the answer came that we have to take both the models of equality and we should apply them as per the needs of the circumstances or conditions, right? So what we basically have is both sense of equality under Article 14 of the Constitution, equality before the law and equal protection of the law. Okay. Now we come to the next article, which is Article 15. And Article 16. These are two articles which are heavily important, and I am going to focus a significant amount of time in the next part upon these articles, and then I will lay out certain categories for you. So अभी हमने Article 14 तक कर लिया है. Let's say I'll do a revision. Article 1 to 4 is the Union and its territory. Article 5 to 11 are citizenship. Article 12 is state. Article 13 is judiciary and judicial review and doctrine of severability. Article 14 is equality before law and equal protection of law. And Article 15 and 16 talks about what you can call equality of status and equality of opportunity. Just another thing which I can mention over here with regard to equality under Article 14 is that equality under Article 14 is granted to all persons, not only to citizens. So for example, if a person from USA is residing in India, but he doesn't have citizenship of India, he has citizenship of the USA. Therefore, what it means to say is that Article 14 grants that the equality before the law and equal protections of the law cannot be taken away even of a citizen of an outside country who is present in the territory of India and forms a part of the population of India, even though not as a citizen but only as a resident or a person. Okay, so this is something that I just want to specify as a bypass remark. Article 15 deals with equality of status. Article 16 deals with equality of opportunity, right? We have seen the presence of these two equalities in the preamble, right? If we talk about preamble, we see equality of status and equality of opportunity. And the way that they have been elaborated in the Constitution is Article 15 talks about equality of status and Article 16 talks about equality of opportunity. So Article 15 says that there must be a prohibition of discrimination. Prohibition of discrimination in the society on the basis of gender, race, caste, creed, place of birth, etc., etc. Okay, and so basically it talks about prohibition of what you can call social discrimination. Clear? Article 16 talks about, as I mentioned previously, prohibition of discrimination in matters of public employment. Okay, you have to be very clear about it. For example, let's say if a person is trying to take some what you can call water from a well, okay, and that person has been told not to come near the well because he is a member of a certain caste, then it is a violation of his fundamental right under Article 15 because he has been discriminated from a social position. Okay, it can also be a violation of Article 17, which is the abolition of untouchability. But if he has violated article, if he, let's say, if he is asked for, if someone doesn't, recognize someone or disrespect someone or discriminates against someone within the society, then it is called a violation of Article 15 of the Constitution. For example, let's say the whole thing about Indians not being allowed into railway cabins of the first class during the colonial times is a violation of Article 15 of the Constitution. If any kind of a discrimination is subjected to a person on the basis of what you can call if any kind of a discrimination is made in the Constitution on the basis of caste or class, or class is not a point over here, sorry, race, gender, place of birth, etc., etc. These are discriminations which are going to be prohibited under Article 15 of the Constitution. If any discrimination is made to any person with regard to giving him a public employment means employment which is, let's say for example, sometimes it is also known by a different term. Let me just replace this by saying the term in terms of offices under the state. Offices under the state. This is a better way of exposing it. It basically means that when you have state under Article 12, legislative, executive, union and state, any kind of a administrative position, any kind of a judicial position, any kind of a legislative position which is given in Sarkar, as you call it, Sarkari Naukri, if any discrimination is made in favor or against any person, it will be prohibited under Article 16 of the Constitution. So Article 15 talks about ohda, status, equality of status, and Article 16 talks about equality of opportunity. Okay. Now, Article 15 and Article 16 are easy to understand and revise, as I have given you the basics of how you can attempt some amount of prelims question from it. What I want to really focus upon in Article 15 and Article 16 is about the exceptions which are given in Article 15 and 16. And broadly speaking, we can have a kind of a understanding about this. Article 15 says that if the state makes any reservations for the upliftment of certain categories of people, it will not be considered a violation of right to equality. And Article 16 says, now basically Article 15 is more or less focused upon reservations in educational institutions. It is focused upon reservations in educational institutions. Question that was asked by Ambedkar was at some point of time, the question that Ambedkar asked was that what kind of a situation can you create for a person to uplift his status? What can you give a person so that the person's person's what you can call status in a society can be uplifted? Is what you can call the audha in a society he can be respected better, right? And one answer which came unanimously to the entire Constituent Assembly was to provide that person with means of education. Okay, and therefore Article 15 provides for the conditions of reservations which are made in the educational institutions. Incidentally, as we read the Constitution today, it talks about reservations both at the public level and at the private level, right? So both public and private institutions, at least from the reading of the Constitution, empower the state. Okay, the state, as mentioned under Article 12, can create a policy of reservations for reserving certain seats at educational institutions, both public and private, to uplift people of certain categories which are mentioned in the Constitution in certain schedules of the Constitution. And similarly, Article 16 talks about reservations in matters of offices of the state. Offices of the state. Reservation in matters of offices of the state. Okay, so very simply, if I can elaborate this, it means this, that if there is a reservation policy which deals with giving reservations to people in educational institutions, it is springing out of Article 15 of the Constitution, which talks about the equality of status, and it talks about uplifting the status of people who have been historically marginalized by giving them access to education, both public and private, under Article 15 of the Constitution. If we talk about reservations in Sarkari Vibhag, in public employment, in offices of the state, then we are talking about reservations which are given under Article 16, equality of opportunity. Okay. So this point is something that we can remember for the prelims examination. Equality of status is associated with equality of what you can call opportunity for. Equality of status can be associated with what you can call education institution reservations, and equality of opportunity can be associated with public employment or offices of the state reservation. Clear? This is one thing that I am trying to indicate. Now, I am going to just elaborate this part with some amount of current affairs which have developed. Okay. So, now I think we are coming at a position that we will be taking a look at some of the intricate developments in the current affairs in the recent years. Okay. Now, I am going to write briefly the name of the chapter, which is affirmative action. And these are the points that I will discuss in the name of the chapter called affirmative action. First point I will discuss, which I have discussed already, is Article 15 of the Constitution. Second that I have discussed is Article 16 of the Constitution. You see reservations in educational institutions and reservations in public employments. Okay. Third that I discuss is Article 338 of the Constitution. Fourth, I discuss Article 338A of the Constitution. Fifth, I discuss Article 338B of the Constitution. Sixth, I discuss Article 340. Seventh, 341. Eighth, 342. And ninth, 342A. Don't be intimidated by the number of these articles. As I am telling you, it's not very important to remember the number, and I am going to open up these articles as to what they stand for. Okay, so for example, I've given you Article 15 stands for the right to equality of status, Article 16 stands for right to equality of opportunity, and Article 15 says that the state cannot be prevented from making any law in which equality of status can be violated. But if the state makes special provisions for the reservations of people in educational institutions, it will not be violative of Article 15 of the Constitution. And similarly, the state can make laws with regard to Article 16 of the Constitution, and any law which is made with regard to giving reservations to public employment, reservations in public employment to certain classes of people will not be violative of Article 16 of the Constitution. Okay. Article 338 talks about National Commission for Scheduled Castes. Article 338A talks about the National Commission for Scheduled Tribes. Okay, so I'm just going to write this: National Commission for Scheduled Castes, National Commission for Scheduled Tribes. Here I can write National Commission for Backward Classes. Article 35 mein again I can write of something similar, which is known as a Backward Classes Commission. For example, the Mandal Commission would be classified under Article 38 of the Constitution, 340 of the Constitution, and Article 341, 342 and 342A are powers to the Union to notify, powers to the Union to notify groups under scheduled caste, scheduled tribe and OBC/SEBC. So what I've done is, in a way, I've laid out to you the entire amount of literature that you have to read in terms of identifying the relevant points within the Constitution of India with reference to the affirmative action. Okay. So for example, Article 15, Article 16, Article 338 National Commission for Scheduled Castes, Article 338 National Commission for Scheduled Tribes, Article 338B National Commission for Backward Classes, Article 340 Backward Classes Commission, and Article 341, 342 and 342A with reference to the powers of the Union to notify groups under SC, ST and OBC, right. Now just take a listing of this, so that whenever you are revising, you can have one small piece of paper on which you can write the number of these articles, and the fact that you are writing the number of these articles with reference to what you are reading will be able to make you revise them properly again and again. Okay. So let me give you a brief way in which you can take a look at what we are looking at. Right. With regard to reservations, we ask the following questions. Okay. The first question that we ask with regard to reservations is, how does the state get the power to provide reservations in educational institutions? If this is a question that we ask, then the answer that we get is under Article 15. The prelims question that can be framed out of this is under equality of status given by the Constitution. Okay. This is one question that we can ask as a frequently asked question. Okay. Second question that we can ask is, how does the state get the power, how does the state get the power to provide reservations in public offices? Answer to that question is under Article 15 equality of opportunity. Okay, please take a note of this. This can be made to structure in a kind of a question in the prelims examination. Okay, the next question that we ask in reservation policy is, what are the categories in which reservations can be provided? Okay, now the answer to that is, number 1, there is what is known as the scheduled caste. Number 2, there is what is known as the scheduled tribe. Number 3, what is known as the socially and educationally backward classes, sometimes also interchanged with other backward classes, SEBC. Okay, these are the 3 classes which have been envisaged in the original draft of the constitution. Okay, now the important point that I am trying to come to is the 4th class, which is known as the economically weaker sections, EWS. Okay, this has been added to the constitution only recently, and that is why you have a kind of a judgment by the Supreme Court of India recently, which is a constitution bench judgment, a 5-judge bench judgment, which talks about certain ideas which are associated with this kind of a situation. Okay, so that's what I'm going to a little bit focus upon. If, let's say, for example, you have a question, which of the following categories were mentioned in the constitution originally, you can have the answer as scheduled caste, scheduled tribes and SEBCs. However, the Supreme Court in the Indira Sani judgment, which I will take elaboration upon, stated that according to its power of interpretation, Supreme Court could also read the OBC to be a part of the constitution. Okay, again I'll repeat the kind of question that you can get out of this. Question is, which of the following categories were a part of the original constitution? Just like, for example, you have a question regarding preamble, which of the adjectives to the preamble were a part of the original preamble? Okay, you can also get a question which states which of the part of the what you can call the categories for reservations were given originally in the constitution, and the categories for reservations which were given originally in the constitution were scheduled castes, scheduled tribes and the socially and educationally backward classes. Okay, the socially and educationally backward classes. This is given in the constitution, right? Now the concept of OBC was not given in the text of the constitution. संविधान के अंदर शुरुआत में जो reservation policy लगी थी 1950 and 1951 में, it was not given originally in the draft of the constitution. Okay, but it was interpreted to be in the constitution by the Supreme Court in the Indira Sani judgment. Okay, and therefore it was understood as being a part of the constitution. But one category which is not mentioned in the constitution, which was introduced by a constitution amendment inside the constitution, is the EWS category, which is the economically weaker sections. So this is the recent addition to the categories which can avail reservations under Article 15 and Article 16 of the constitution, right? So this is a part that you have to take a little bit of a look at. Okay, so let me just repeat to you again. What are the categories in which reservations can be provided? Now, the categories overall in today's terms are scheduled caste, scheduled tribes, SEBCs and EWS, and these 3 can be read in the original intent of the constitution makers. But EWS was not in the original intent of the constitution makers. It was introduced in the constitution by the constitution amendment, right? The constitution amendment which introduced the EWS is the 103rd Constitution Amendment Act, which was imposed in year 2019. Okay. नहीं, ये अच्छा क्वेश्चन. इनविंसिबल ओबीसी वाला अमेंडमेंट से नहीं आया. देयर इज नो अमेंडमेंट मेड टू द कॉन्स्टिट्यूशन टू इंट्रोड्यूस द ओबीसीज. OBCs were interpreted into the Constitution, Article 15 and 16, by the Mandal Commission report, and the Supreme Court upheld the validity of the Mandal Commission report and said that if you read the intent and the logic of Article 15 and 16, you can interpret that OBCs can be a part of it. Okay, so it was not introduced. Even today, for example, if you look at the language of Article 15 and 16, it doesn't mention other backward classes. It only mentioned socially and educationally backward classes. But the Supreme Court said that the socially and educationally backward classes and what you can call the concept of backward classes can be read into the Constitution. Okay? So that's what basically we are saying, that this was interpreted in the Constitution. The only thing which was added into the Constitution, which was not there in the original intention of the Constitution, is EWS, and this is given by the 103rd Constitution Amendment Act made in 2019. Okay, so this is a point that I want to lay a little bit of a focus upon. Okay. The next question that we can ask with regard to reservations is that how does the government decide which groups of people can be notified as A, scheduled castes, B, scheduled tribes, C, SEBC/OBC, and D, economically weaker sections. Okay? Now let me give you the answer to this question. How does the government decide which groups of people can be notified? मतलब प्रश्न ये है कि मान लीजिए कोई एक group of people है, let's say there's a caste or a subcaste which is protesting by blocking the railway tracks about what is called the which is protesting which is blocking the railway tracks by giving a kind of a call for giving them reservations, right? तो वो reservations के basis पे they are trying to protect and block out the railway tracks. Now, if the political party which is in power, they are being made demand to that this group or class should be given reservations to, how does the political party which is in power take this decision? Is it based upon any scientific basis? Is it based purely upon political agenda or political mobilization? मतलब राजनीति के अलावा क्या कोई और नीति है, कोई विज्ञान है, कोई ज्ञान है ये डिसाइड करने के लिए कि किसी को रिजर्वेशन दिया जाता है तो वो किस आधार पे दिया जाता है? एंड वी कैन आस्क अ क्वेश्चन अबाउट what is the scientific basis upon which a particular group or a subgroup has been given reservation. The Constitution answers that question by creating what are known as constitutional bodies. आपके मेंस के पेपर के लिए एक हेडर दे रखा है जिसको कहते हैं constitutional bodies, right? और एक जो constitutional body है जो कि बात करती है reservations की, मतलब जो कि आधार बताती है कि किस बेसिस पर reservation दिया जा सकता है scheduled caste को, उसको हम कहते हैं National Commission for Scheduled Caste. Right? That is the articles that I am trying to refer to. For example, let me take you to the draft of the Constitution of India. If you go to the article 338 of the Constitution, it talks about a constitutional body which is known as the National Commission for Scheduled Castes. ठीक है, तो जैसे आपने जब अपने पॉलिटी के पेपर्स के बारे में पढ़ा होगा तो आपने कॉन्स्टिट्यूशनल बॉडीज के बारे में पढ़ा होगा. लेट मी गिव अ वेरी सिंपल डेफिनेशन ऑफ व्हाट अ कॉन्स्टिट्यूशनल बॉडी इज. अ कॉन्स्टिट्यूशनल बॉडी इज अ बॉडी व्हिच हैज बीन गिवन birth to by the Constitution. So for example, let me elaborate this a little bit as a note. Three kinds of bodies are something that we have to read in polity. Okay. One kind of body is constitutional bodies. For example, the example of constitutional body are, let's say, the Election Commission of India under Article 324, or what we have discussed as the National Commission of Scheduled Caste under Article 338, or for example, National Commission of Scheduled Tribes. under Article 338A, right? Or let's say CAG or the Finance Commission under Article 280, 281. These are known as constitutional bodies. The point about constitutional bodies is that they are born by the what you can call the will of the constitution itself. Okay, they are born by the will of the constitution itself. They are not supposed to be altered by the parliament except by the provisions which are provided under Article 368 of the constitution. Okay, so for example, if you have the Finance Commission or the National Commission of Backward Classes or Scheduled Castes, it is something which has been made by the constitution itself, right? And therefore the parliament, the legislature, cannot unmake that constitutional body at its will. It requires a huge amount of power under Article 368 to, let's say, dismantle a body like the Election Commission or the National Commission for Scheduled Castes. Okay. The other kind of body which is something that we study in polity is what is known as statutory body. Okay. Statutory body is a body which is not made by the constitution, but it is made by the parliament. So for example, let's say the instance of a statutory body is the Reserve Bank of India, which is made by the Act of the Parliament 1934. This is the Act of the Parliament which has given birth to Reserve Bank of India. Or for example, let's say Delhi University, or for example, let's say State Bank of India. These are bodies which are made by a statute. Statute implies a law made by the parliament. This is basically what is made by the statute. And then you have the non-statutory bodies. For example, bodies which are made by an executive order or an administrative order. Right? For example, you have the Niti Aayog, which has been given birth by a cabinet approval. Or before Niti Aayog, you had another non-statutory body which was known as the Planning Commission. Okay, so this can be a simple conceptual understanding as to describe what is the meaning of constitutional body or distinguish between constitutional bodies and statutory bodies. A conceptual distinction between the two is that constitutional bodies can be amended or moved out of the constitution only by following the procedure under Article 368, and that too is subject to judicial review under the basic structure and doctrine. Okay, Article 368 can be used to amend or let's say disempower a constitutional body, but Article 368 is a strict procedure and it is also subject to a heavy inspection of judicial review under the basic structure doctrine, which effectively means that the parliament, if it wants, it cannot do away with National Commission of Scheduled Caste or Scheduled Tribes or Election Commission of India. स्टैट्यूटरी बॉडीज के लिए आपको आर्टिकल 368 की जरूरत नहीं पड़ती। आप स्टैट्यूटरी बॉडीज को ऑर्डिनरी लॉ से बना सकते हैं और उनको मिटा भी सकते हैं, और इसमें जुडिशियल रिव्यू बहुत लिमिटेड लगता है। अल्ट्रा वायर्स के लेवल पे ही जुडिशियल रिव्यू रख सकते हैं, अदरवाइज इसमें जुडिशियल रिव्यू नहीं लगेगा। ठीक है। एंड इन नॉन स्टैट्यूटरी बॉडीज यू डोंट इवन नीड द परमिशन ऑफ द पार्लियामेंट। द कैबिनेट इटसेल्फ, द गवर्नमेंट at the union level and at the state level respectively can create and uncreate, make and unmake a statutory body, non-statutory body, without the permission of the parliament or the permission of the constitution, which for example means the planning commission was made by a cabinet approval and the planning commission was dissolved by a cabinet approval. Okay, so this is a simple distinction that we can understand at this point between what you can call a statutory body and a non-statutory body and a constitutional body. Now, coming back to our understanding, the decision, the science, or what you can call the data analysis, the sociological analysis of understanding who can be notified as a scheduled caste and what steps can be taken for the further advancement of scheduled caste is given as a power to a constitutional body under Article 338 of the Constitution, which is known as the National Commission for Scheduled Caste, NCSC, National Commission for Scheduled Caste. Okay, this is something that you can remember. Again, for example, let's say Article 338 of the Constitution, there shall be a commission for the scheduled caste to be known as the National Commission of the Scheduled Caste. Okay, and the jobs and the functions and the powers of the National Commission of Scheduled Caste don't need to be memorized. You just have to get a sense of what the basic idea of the National Commission of Scheduled Caste is, that it basically takes up the data, the sociological data, the anthropological data, and examines the data and gives recommendations to the government of India as to what steps can be taken to improve the conditions of the scheduled castes, and also what castes or what groups can be, what you can call, added into the category of scheduled castes and removed out of the category of the scheduled castes. So it's like a think tank which sends its recommendations to the government of India with regard to what is the nature and status of scheduled castes in India, with sociological, anthropological, and what you can call a kind of a a knowledgeable aspect of what is supposed to be the real aspect of how to determine a particular caste as a scheduled caste or a tribe as a scheduled tribe. Similarly, under Article 338A, you have another constitution body which does the same thing exactly for the scheduled tribes, known as the National Commission for Scheduled Tribes. Okay, this was introduced into the constitution by an amendment, and therefore this kind of an activity is again the nature of the 338A is to produce a National Commission of Scheduled Caste which can give the government recommendations upon the status of scheduled castes in India and how the scheduled castes can be advanced, and also what groups of people can be identified as scheduled castes and what can be taken out of the categories of the scheduled castes. Then you have the SEBC and OBC for which the constitution was amended, and Article 338B had was inserted in the constitution to provide for what is known as a National Commission for Backward Classes. Okay, National Commission for Backward Classes was not there in the original constitution. Again, as a point that you can remember for the prelims examination, it was not the original intent of the constitution to have a National Commission for Backward Classes. Okay, the original intent of the constitution was only to have a what you can call a Backward Classes Commission. So I will just explain to you the difference between the two. This is going to be relevant to understand because the whole Indira Sahni judgment and the EWS quota judgment is ridden with this literature. Okay, कि मतलब जो भी हमारा reservations और affirmative actions में जो भी constitutional bodies है etc. उनके सारे नाम आपको याद करना important इस समय इसीलिए क्योंकि जो अभी EWS का judgment आया सुप्रीम कोर्ट की 5 judge bench का, which is a bit of a landmark judgment, which is a landmark judgment which basically makes a huge exposition of all these activities which are happening under affirmative action. Okay, so basically अगर हम देखें तो Article 338B was introduced into the constitution by an amendment. Okay, and Article 338B also established is a constitutional body which is supposed to have the scientific and the anthropological basis on which the judgment about what is a backward class, which includes an OBC and an SCBC, can be identified as, right. So just take a look at Article 338B of the Constitution. Article 338B of the Constitution talks about National Commission for Backward Classes, introduced by the Constitution 102nd Amendment Act 2018. Right, 102nd Constitution Amendment Act 2018 introduced the constitutional body which is known as the National Commission for Backward Classes. Okay, and it has exactly the same agenda as National Commission for Scheduled Castes and National Commission for Scheduled Tribes, just that it has it for the National Commission for the Backward Classes. Okay, matlab to identify who are the backward classes, to give recommendations to the government as to the upliftment of backward classes, and to make sure that the status and nature of backward classes is moving into a progressive direction, to do a scientific, sociological and anthropological research upon their identities and their what you can call upliftments, is the work of the National Commission for Backward Classes, which is introduced by the 102nd Amendment Act 2018. Okay, now before the National Commission for Backward Classes was in a way made a constitutional body by amending the constitution under Article 368, there was what is known as a Backward Classes Commission. right? This is under Article 340. For example, if you ask the question about what is known as the famous Mandal Commission. Okay, so for example, if a question is asked in the UPSC about the nature of Mandal Commission under the Constitution, the Mandal Commission is not the National Commission for Backward Classes. Okay, Mandal Commission is something which is a part of Article 340 of the Constitution. A Mandal Commission was formed on first time in 1979, and it gave its report in 1980 onwards, and then it was implemented in 1990. Okay, but Mandal Commission was not a National Commission for Backward Classes. It was what is known as a Backward Classes Commission made by the Government of India under the powers given to the Government of India under Article 340 of the Constitution. This kind of a distinction is going to become relevant for the prelims examination this time, because the Mandal Commission report and the Indira Sahni judgment were in news again and again this time because of the EWS quota judgment. Okay, basically what we take a look at is the fact that the nature of Backward Classes Commission is slightly different from the nature of what you can call the, let's look at it. You have the Backward Classes Commission under Article 340, and you have the National Commission for Backward Classes under Article 338B. Right? You can have a question which compares the two in some way or the other in the prelims examination. Okay. Now, let's say for example, one of the differences that it was a part of the original Constitution, National Commission of the Backward Classes. Okay, and this, what you can say, became a part of the Constitution by amending the Constitution. It is not a part of the original Constitution. Okay. Number two, it leaves at the discretion of the government if a commission has to be appointed. Okay, so let's say for example, there are two Backward Classes Commissions which have been appointed in history. Okay, one is known as the Kaka Kalekar Commission, which is known as the first Backward Class Commission, which was established in 1953, and it gave its report in 1955. This was known as the first Backward Classes Commission. Okay, the second Backward Classes Commission was introduced way later, which was of course known as the Mandal Commission. Right, and the report of the Mandal Commission, was introduced, was established in 1979. It prepared its report in 1980, and the implementation of the Mandal Commission report was done in the year 1990. Okay, so this is what is known as, for example, in your reference books, you can write as the first Backward Class Commission, and this is known as the second Backward Class Commission. Okay, so what you can see from this nature is that in under Article 340 of the Constitution, it says that the President may by order, and the defining feature over here is may, which is not shall. Okay, so basically the first time that the President did establish a Backward Class Commission was in 1953, and the second time it established was in 1979, which means that it leaves a room for the discretion of the President to appoint a commission under Article 340, which basically means that if a review has to be done as to which group of people should be identified as the SCBCs or the OBCs, that review can be done only when the President wants to appoint a commission for that. There is not a permanent commission which is appointed under the Constitution of India for the review of the status of the schedule of the other backward classes and the socially and educationally backward classes. Okay, this was the procedure which was given in the Constitution with regard to the commission for the backward classes. Now, with the introduction of Article 338B, in the Constitution, what you have is a permanent commission for backward classes. Sometimes it is also known as a permanent commission of backward classes. which is very different from Article 338A. Now, what you see in Article 338B is the fact that states there shall be a commission for the socially and educationally backward classes to be known as the National Commission of Backward Classes. Okay? So, sometimes it is also known as the Permanent Commission. It is not left at the discretion of the President to appoint a backward class. Okay? It is not left at the discretion of the President to appoint a backward class. It is something that must be appointed by the President, because the term over here is shall. Okay? So, this is the point that I am trying to clarify over here, which means that you have the government which may appoint a national commission, the commission for backward classes under Article 40, for example, the Mandal Commission. But over here it is mandatory for the government of India, the President, which says that it must or it shall appoint members to the National Commission for Backward Classes, and this is a commission which exists 24/7, 365 days, and any matter can be referred to it by the government, and the government will have an answer from this in terms of giving it a think tank ability to identify the backward classes in India. Okay? Yes, you're right in saying that Article 338A also made an amendment into the Constitution to insert about the National Commission for Scheduled Tribes. The National Commission for Scheduled Tribes was not in the original draft of the Constitution, it was introduced into the Constitution by the 89th Amendment Act 2003. So, anyone who is asking about what Amendment Act was passed in 2003 with regard to reservations, it was the 89th Amendment Act 2003, which was passed in reference to reservations. Okay? You get a sense about how this kind of a situation is arising. So, let me just do a kind of a recap about the entire reservation system before we get lost in the detail and specific points to remember at the prelims examination. You have Article 15, equality of status, Article 16, equality of opportunity, reservations in educational institutions, reservation in public offices. Okay? Then you have Article 338, which is the National Commission for Scheduled Castes, which was in the original Constitution. Article 338A, National Commission for Scheduled Tribes, which is from the 2003 Amendment Act. Then you have the National Commission for Backward Classes. This is also put in the Constitution by an amendment. So, this gives a list of castes which it thinks on a scientific basis to the government of India in terms of identifying if they are fit to be classified as scheduled castes, scheduled tribes and backward classes. These are the constitutional bodies, the scientific think tanks which are supposed to operation and assess the sociological and anthropological data in terms of assessing whether a particular group of people who are protesting to be included in the backward classes, etc., are eligible for such kind of a movement inside that category. Okay? So, this is the next question that we answer. Then the question that we answer is, within the state as mentioned under Article 12 of the Constitution, okay, within the state, which organ of the state and which level of the state can identify groups into SC, ST, OBC, and then we will talk about EWS. Please pay attention to the minute details of this discussion, because anything from here can be converted into a prelims question. As the EWS quota judgment was given only this year, you are going to see a lot of action in the prelims examination from this part. So, I am summoning your attention with some responsibility. Okay. So, within the state, but basically the question I am asking is, let us say if there is a caste called caste X. Okay. Now let's say the caste X is demanding to be included in the category of OBCs. Okay. You have the state as it is given, the union, the state, the legislative and the executive. Okay. So within the state, which of the organs does have the power to notify? Is it with the, let's say, the Prime Minister of India, who is a union executive, or is it with, let's say, is it with the Prime Minister who is a union executive, or is it with the union parliament, the Lok Sabha, which is a union legislature, or let's say it is with the state executive, the Chief Minister, or it is with the state legislature, the Vidhan Sabha. Who has the power to notify a particular caste or a group of people who is trying to notify themselves under the other backward classes category? This is the question that we are asking. Okay. Now, the answer to that question is very simply categorically put out over here. When it comes to the scheduled castes, what we have to refer to is Article 341 of the Constitution. Just let me put you out over there. Okay, and we'll read it together. And this is going to be important for us to memorize properly. This could be a little tricky if you have not been able to cover in your static portion. Now is a good time for having a clear understanding of them, and I'll go slowly about it. Okay. So, for example, just like you have Article 338, which talks about the National Commission for Scheduled Castes. National Commission for Scheduled Castes. Okay, which is like a think tank which suggests to the government as to what castes can be included in the category of the scheduled castes, right? Okay, it has what you can call a recommendatory power. Okay, now under Article 341 of the Constitution, it is said that the power to notify the scheduled caste is with the President of India, but of course, the President is only a nominal head. The President is working upon these powers on the aid and advice of the Prime Minister and Council of Ministers. Okay, so the recommendations are to be made to the President, who make under these recommendations or bypassing this recommendation, notify a particular caste X as an OBC. Okay, this is the point that we're trying to make. Again, I'll repeat it. With regard to scheduled castes, NCSC, which is a think tank, recommends to the President that a particular caste can be notified as a SC. Now, the President may look at the recommendations given by the National Commission of Scheduled Castes, but he is not obliged or bound by the recommendations. And maybe on the basis of the recommendation, or maybe upon his own political calculation, he can notify a particular caste under the category of the scheduled castes. This power is given to the President under Article 341 of the Constitution. But this power is not only given to the President. The list that is created by the President of the notification can be modified by the Parliament. Please listen to this very carefully. A very clever constructed prelim question can be asked on it. Okay, list is notified by the President, but the Parliament also has the powers of reviewing the induction of a caste as SC. Okay, so what I'm trying to say is that the Parliament, if it gets a list as to the number of castes which have been inducted in the category of scheduled castes, the Parliament under Article 341 has the power to add another caste in this list or to strike out any caste in this list by passing a motion. Okay. You see the point? Let me just repeat it again. Slowly and clearly, I'll go through this again. Under Article 338 of the Constitution, the National Commission for Scheduled Caste is appointed, is established. It is a permanent commission. It is not at the discretion of the President that it is established, and it provides recommendations to the President to include a certain caste into the scheduled caste. The President may consider these recommendations and create a list of castes which are the part of scheduled caste now. Once this list has been created by the President, it can be reviewed by the Parliament, and the Parliament can add a name to the list and cross out to the name to the list, right? These are, for examples, the powers of the Parliament to check and balance the power of the executive, right? So, a kind of a shared power is given to the Union Executive and the Union Parliament to notify the scheduled castes in the category given under Article 15 and 16 reservations. No power has been given with regard to scheduled castes to the state governments. That's a very simple prelims kind of a trick question. Has any power been given to the state governments with regard to inclusion of certain categories or certain classes of people under the scheduled caste category? No power has been given to the state government. राज्य की सरकारों को, प्रदेश की सरकारों को कोई भी पावर स्टेट गवर्नमेंट के अंदर नहीं दे रखी है, मतलब स्टेट गवर्नमेंट को नहीं दे रखी है. अगर कोई मध्य प्रदेश में कोई एक गुट है जो कि शेड्यूल्ड कास्ट में एंट्री करने के लिए प्रोटेस्ट कर रहा है, तो उस गुट को शेड्यूल्ड कास्ट में एंट्री देने की जो पावर है वो सिर्फ केंद्र सरकार के पास है, केंद्र एग्जीक्यूटिव के पास है, प्राइम मिनिस्टर और काउंसिल मिनिस्टर्स के पास, और उसके एक्शन को रिव्यू करने की पावर पार्लियामेंट के पास. इस एक्शन को लेने से पहले केंद्र का जो एग्जीक्यूटिव और नेशनल कमीशन फॉर शेड्यूल्ड कास्ट की रिपोर्ट को देखकर अपने आप को सूचित कर सकता है. ही कैन इन्फॉर्म हिमसेल्फ ऑन द बेसिस ऑफ द रिपोर्ट विच इज गिवन बाय द नेशनल कमीशन फॉर शेड्यूल्ड कास्ट्स. ओके, बट ही इज नॉट बाउंड बाय दैट रिपोर्ट. इट इज ओनली recommendation in nature which is not binding upon the president, and no power is given to the state governments to notify scheduled caste. So even if I am staying in a particular state in India, if I have to ask for my rights as a scheduled caste, if I have to be asked for being included in the scheduled caste, I can only ask that from the central government. I cannot ask it from the state of Uttar Pradesh or Madhya Pradesh or Rajasthan, whichever state I am a resident of, right? That's one thing that we have to understand very clearly in terms of getting a clarity on the prelims part. Okay? Okay. Next we ask the question about scheduled tribes. Again, I'll make the same effort about it. Scheduled tribes are mentioned under Article 338A. You have the National Commission for Scheduled Tribes, NCST, National Commission for Scheduled Tribes, right? And the National Commission for Scheduled Tribes is, of course, what we have understood as a think tank, right, which is constituted as a permanent commission of scheduled tribes, and then the National Commission for Scheduled Tribes under Article 342 gives the recommendations to the President, which is again the President, but with the Prime Minister and Council of Minister aiding and advising. The President is bound by the aid and advice of the Prime Minister and Council of Ministers. They can notify a caste, a tribe, as a scheduled tribe. They can notify a tribe as a scheduled tribe. Clear? And the notification of a tribe as a scheduled tribe can then be reviewed by the Parliament, in which if a list is provided to the Parliament about the actions of the executive, that these groups have been identified as scheduled tribes, and the Parliament can add another entry to the group or remove an entry from the group. The Parliament can add an entry to the group or remove an entry to the group. Okay, so the power to notify the scheduled tribes is finally shared between the President and the Parliament, and the 338 in National Commission for Scheduled Tribes gives a kind of a think tank assistance, but the nature of this is only recommendations. It is not mandatory for the President to go with the recommendations of the constitutional body known as a National Commission for Scheduled Tribes. Okay. Now the next question is, what happens with regard to the other backward classes slash the SEBCs. In the constitutional scheme of things, the OBCs and SEBCs are interchangeable terms. SEBCs. Okay. Again, let me put out very simply. You have Article 338B, which has a National Commission for Backward Classes, which gives the power to the constitutional body of National Commission of Backward Classes to create recommendations. Earlier, this power was enjoyed by the president, who could at his own time and discretion create a backward classes commission. But now this doesn't work. You have the 338B, National Commission for Backward Classes. Okay. For example, the National Commission for Backward Classes under Article 342A again follows the same pattern. The president can take cognizance of the report of the NCBC and then notify a list, and then the parliament can exercise the powers of checks and balances to the power of the president to notify a caste as a other backward class or a scheduled socially and educationally backward class. Article 342A was introduced into the constitution by a Constitution Amendment Act. Okay. Now, this is a point that I want to refer to it, and then I'll move to the judgment given by the Supreme Court in a famous judgment which is also known as the Maratha reservation case, which came out only last year, and we take a look at the Constitution bench judgment. The Article 342A of the Constitution was introduced into the Constitution by the 102nd Amendment Act 2018. You can take a note of this. Okay. 342A was introduced in the Constitution by 102nd Amendment Act 2018. Okay. Now, with the introduction of this act, the modification that has been made is that earlier, while identifying the OBCs, before the Amendment Act was introduced in the constitutions, the identification of OBCs was shared between the union government and the state government. What I basically mean to say is that, let's say, if you have a job under a subject which is given under union list, let's say, for example, let's say defense. Defense is a subject under the union list. So, to identify the other backward classes reservations, the classes for reservations as other backward classes in the defense sector or category is to be decided by the union government, because defense is a union subject. Okay, so who will become a other backward class in terms of getting a quota for reservations under the defense jobs which have come out in Article 16, public employment, will be decided by the union government, and correspondingly anything which is under the state government, let's say, for example, fisheries, which could be a state subject. If any kind of a job opens up, who will become an OBC, who will be able to avail the benefits of reservations in this sector if a public job is coming up, it will be decided by the state government. Similarly, for the union universities who are central universities, for example, Delhi University or other universities which are central, केंद्रीय विश्वविद्यालय है, उनके लिए जो decide होता है कि कौन government ये decide करेगी कि इसमें किस group of people को OBC का दर्जा दिया जाए, वो केंद्र सरकार करती थी. लेकिन जो state universities होती थी, उसमें OBC किस group को दिया जाता था, वो राज्य सरकार होती थी. इसीलिए for example, you may have noticed that different castes have been given different identifications in different states of the OBCs and the SEBCs. Okay. The question that we have now modified is that after the introduction of Article 342A into the Constitution since 2018, the power of the state has been taken away, and for all jobs and all educational institutions across the board, whether it is union or state, the power has been given to the union government. That's a modification that has happened. Right? This is a recent modification under Article 342A of the Constitution, which became the crux of the Supreme Court judgment in the Maratha reservation case for the OBCs. Right? Take a look at this. To answer your question, Shubham, just take a look at the Article 342A. The President may, with respect to any state or union territory, and where it is a state after consultation with the government thereof, right? So the whole thing is that the president has the right to take a notification out of telling which group of people will be called in OBC with regard to a state and union territory, and it can only take a consultation with the governor thereof. Now, you know what it means. For example, let's say if there's a group of people in Haryana who are asking for the reservation as OBCs, right, and they are making the demand to the state government. Now, the state government, if it issues a notification saying that that group is a part of OBCs for all the universities which are under the Haryana government, which are under the state, and if the government of India issues a notification which says that that group is not a part of the reservations under OBCs, the reservation notification of the government of India will prevail over the state reservation notification. You see, that's the point. What it provides is that the president may make a notification of any state or union territory as a part of the OBC quota, and he may consult the governor. Now, all of you know, for example, governor is only a person who has been appointed by the president. Governor doesn't come from the legislative assembly or the government of the state legislature. He is a person who has been appointed by the president. So, in saying that the governor is going to be giving the consultation means that you're just in a way doing the same thing that you want. You're not taking any consultation from the state government of the chief minister, council of ministers, right? And this kind of an indication is what we are taking a look at in terms of we're getting a very clear sense that after the amendment made into the constitution in in article 342A, the power to notify OBC for the entire country of India has been given to the union government. Previously it was with the state governments, but for the state universities and state employments and etc., etc. But recently, with the amendments in the constitution, the entire power has been granted in the hands of the union government. Now, this became exactly the point of contestation in a case which is known as the Maratha reservation case. Okay? But I'll come to that in a point to get you a sense of what is basically happening in the background. So, at this point of time, I feel I have made a good coverage in making you understand the structure of reservation. Now, this is extremely relevant for the prelims examination. Article 15, Article 16, Article 338A, Article 338B, Article 340, Article 341, Article 342 and Article 342A. If you take a look at all of these articles in the Constitution of India, you will get a sense of all the information that is relevant in the Constitution which associates itself with the reservation policy. Okay. So, these articles I think have done right to equality of status, right to equality of opportunity, National Commission for Scheduled Caste, National Commission for Scheduled Tribes, National Commission for Backward Classes Commission, for example, the Mandal Commission, the powers given to the president in terms of notifying scheduled castes, the powers given to the president in terms of notifying scheduled tribes, the powers given to the president in terms of notifying the backward classes. This has been amendment to the constitution in the year 2018 and is going to be of some significance for you to understand in the current affairs. So, for example, if a question comes that who has the final authority to decide OBC, is a state government or a union government, the answer is going to be the state government. If there is a contest between the union government and state government, one wants to give the status of OBC, doesn't want to give status of OBC to a particular caste, the will of the union government shall prevail, as it can clearly be read in Article 342A of the Constitution. Okay? Now, let me just put you in touch with one of the what you can call judgments which have been given by the Supreme Court Constitution Bench. This is a case which we are going to take a little bit of a discussion of. A Constitution Bench judgment from which a question can be possibly asked. Again, I am telling you this reference with current affairs because the question of EWS and the question of the OBC under Article 342A notification is a little bit of a relevant question in the recent times. A 5-judge constitution bench of the Supreme Court on Wednesday struck down the Maharashtra law granting reservation to the Maratha community in admissions and government jobs in the state. The court had framed 6 questions of law on the issue, right? So, one of the grounds on which basically the history of this is that the government of Maharashtra had notified the community of the Marathas as a other backward class for the, or let's say the socially and educationally backward class for the purposes of public employment and educational institutions with regard to subjects which fall under the state list for the state of Maharashtra. Okay, so for example, if there's a college, let's say there's a government college which has been established by the state of Maharashtra, the Marathas were given the status of an OBC community within that particular state. Okay, within that particular university for educational institution reservations. Now, the Supreme Court said that after the introduction of Article 342A, the power cannot be exercised by the state government. The power has to be exercised by the union government. Therefore, if the state government makes a reservation on the other backward classes, then the state government is acting out of its authority, or what you can call ultra vires. Take a look at this. This is a point that I have to identify very clearly as a part of your current affair. The Constitution 102nd Amendment Act 2018 gives constitutional status to the National Commission of Backward Classes. The amendment also gives the President powers to notify backward classes, and several states raised questions on the interpretation of the amendment and argued that it curtails their powers. Okay? The bench unanimously upheld the constitutional validity of the 102nd Amendment, but differed on the question whether it affected the power of states to identify socially and educationally backward classes. Okay, so now the first question that was raised in this particular judgment, which is known as the Maratha reservation judgment, or what is known as the Maratha SEBC judgment, is that the constitutional validity of Article 342A was established to be perfect. There is nothing invalid with the introduction of Article 342A into the Constitution of India. Okay, and the majority bench in this judgment also held that. Take a look at this. In the task of identification of SEBCs, the President shall be guided by the commission set up under Article 338B. Its advice shall also be sought by the state in regard to policies that might be framed by it. If the commission prepares a report concerning matters of identification, such a report has to be shared with the state government, which is bound to deal with it in accordance with the provisions of Article 338B. However, the final determination culminates in the exercise undertaken by the President. Now, this is the judgment of the Supreme Court, which once and for all clarifies the idea that the right to notify any group of people, whether it is in Haryana or in Rajasthan or in Bihar or Uttarakhand or Goa, any group of people protesting to be included as a part of the category of OBCs can be given that kind of an induction by the President, not by the state government, after the introduction of Article 342A and Article 338B of the Constitution. Okay, so the President is supposed to be bound by is supposed to be in cognizance of the recommendations made by the National Commission for Backward Classes, but the final determination shall be made by the President with or without applying the theories or the what you can call the recommendations which are given in this particular category. Are we clear about it? Right? Okay, so this is what we are calling the Maratha judgment case. So let me just add another point that we are going to take a look at, the Maratha judgment case, the Maratha reservation case, which is a 5-judge bench Supreme Court judgment, in which the action of the Maharashtra government to notify the Maratha community as OBCs was declared as illegal ultra vires because the 342A Constitution Amendment Act made it the prerogative of this union government to identify OBCs. It is another thing to say that the union government may let the states identify it. But if it happens to be the case that the union government has identified certain people as OBCs, the state government cannot disidentify them. If there is a contest between the union list and the state list about OBCs, the union list will prevail. Let's say, for example, if you have been given the status of an OBC by a state government, but the union government has categorically said no to your inclusion as an OBC, then you will not get reservations even under the government offices which are under the administration of the state government, and public educational institutions or private educational institutions set up under the state. Okay, it cannot happen unless there is a a kind of a situation which has been given to the government of the central authorities. Okay, that's where we are. Fine. Now, so we are covering one by one the points that are going about reservations. Take it. So at this point of time, I've clarified to you a lot of structure about reservation. Article 15, Article 16 talks about scheduled castes, scheduled tribes, and the other backward classes. Let me give you a brief history of what is known as the other backward classes in terms of 2 or 3 points. What are the OBCs? Okay, so let's ask the next question. What are the OBCs? And how is the concept of OBCs becoming relevant in the Constitution of India? Okay. Now, as you can see under Article 342, in 1979, a backward classes commission known as the Mandal Commission was appointed by the President. This was done by the Morarji Desai government, and the Mandal Commission gave its reports in 1980. Okay, Mandal Commission gave its report in 1980, and it called for reservations in public educational institutions and private educational institutions also, and what you can call public offices under the state, for a class of people known as the other backward classes. Okay, so it identified 3 categories of reservations can be given to the SCs, to the STs, and to the OBCs. Okay, in 1990, the reservations which was given to the OBCs was made a part of the reservation policy of the VP Singh government. Okay, so it is between the Narasimha Rao government and the VP Singh government that the reservation policy was issued, and OBCs were given a quota in both these aspects, right? So OBCs were given a quota of 22.5% in the what you can call the Mandal Commission report, and this policy was inducted, was made a part of what you can call the reservation policy formulated by the VP Singh government and the Congress government in 1991, which made a policy in which it is going to give reservations in public institutions and public educational institutions and government offices to the SCs, to the STs, and the OBCs, other backward classes. Okay. Now, the induction of the other backward classes in this reservation policy, let me just elaborate this a little bit. In 1990, the reservation policy that was made, it talked about SCs as a category, STs as a category, OBCs as a category, but is also introduced another category known as the EWS. Okay. So, for example, if you have a question in the prelims examination that when was the first time that the category of EWS was introduced, it is not in the 2019 elections in the amendments, right? The category of EWS has been introduced before in the constitutional scheme of things in the 1990 reservation policy, but it was not a part of the Mandal Commission. Okay. Please be clear. EWS not mentioned in the Mandal Commission. These little bit of facts are important to remember for answering questions on the prelims, as I am specifying that the EWS is a huge judgment by the Supreme Court this year, is not a part of the Mandal Commission, but a part of the 1990 1991 reservation policy. So the government introduced the concept of EWS out of its own accord. It was not mentioned in the what you can call the reservation policy of the what is called the Mandal Commission, right? So for example, what we have in terms of the reservations which are given in this particular regard was 27% of the reservations were given to OBCs, 22.5% reservations were given to SCs and ST combined, and 10% reservations were given to the EWS category under the 1990 reservation policy. Clear? That's one part. This reservation policy was challenged before the Supreme Court in the landmark judgment of Indira Sahni. It was Indira Sahni versus Union of India, in which the constitutional validity of this policy was challenged before the Supreme Court, and we'll take a look at some of the aspects of the Indira Sahni judgments which came out as a result of the discussions which were made in this thing, and I'm going to underline for you the basic ideas about how the Indira Sahni judgment sought to in a way address some of the questions with regard to the OBCs. Okay, so you have Indira Sahni versus Union of India 1992. Okay, so I'm just going to elaborate upon the points about it. What is the main observations of the Indira Sahni judgment? What are the main observations of the Indira Sahni judgment? Okay, the first observation of the Indira Sahni judgment, or let's say for example, let me put it in a question answer format. Okay, question: is the category of other backward classes constitutionally valid under Article 15 and 16? Okay. This is the question, and the answer given by the Indira Sahni judgment in the Indira Sahni judgment by the Supreme Court is that yes, there is nothing unconstitutional about the category of other backward classes. It can be read into the Constitution because Article 15 and Article 16 both mentioned the term backward classes and socially and educationally backward classes. So combining these two terms, you can conceive the concept of other backward classes. तो जो मंडल कमीशन में जो other backward classes का जो concept था, वो Constitution Bench ने इंदिरा साहनी judgment में valid declare कर लिया. Okay, the bench declared the judgment made by the bench in this particular case said that the Constitution is a very clear undertaking in which the backward classes under the Constitution can be read to conceive the concept of the other backward classes. This was the first question which was given by the Indira Sahni judgment. Okay. The second question which was to be decided was, is there a cap or a limit to the maximum percentage of reservations on the total number of seats? ठीक है, तो इसमें बोला था कि क्या रिजर्वेशन किसी भी परसेंटेज तक जा सकता है और इज रिजर्वेशन गोइंग टू बी लिमिटेड बाय सम फैक्टर somewhere or the other. The answer given by the Supreme Court in this was that yes, there has to be a cap, and the Supreme Court took 50% as a point in which this cap has to be realized. Okay, so it said, Supreme Court very categorically said that the total number of reservation, the maximum reservation percentage of the total number of seats cannot exceed beyond 50%, except, okay, subject to what the Supreme Court call exceptional circumstances. This was a second observation made by the Supreme Court in the Indira Sahni judgment. Indira Sahni versus Union of India, the judgment which was made by the Supreme Court. Okay. A third question that was asked of the Supreme Court was, do all OBCs qualify for reservation? This was the next question asked of the Supreme Court in the Indira Sahni judgment, and the answer to that was that there has to be a distinction made within the OBCs. There has to be a distinction made within the OBCs between what is called as the creamy layer and non-creamy layer. Right, and later on a criteria was set out for creamy layer, which was 8 lakh annual family income plus some additional property requirements. Okay, so the judgment which was made over here said that all OBCs do not qualify for reservations. Reservations in OBCs have to be determined as a difference between creamy layer and non-creamy layer, and the criteria of 8 lakh annual family income will distinguish anyone who has 8 lakh and above annual family income will be called an creamy layer OBC, who will not have the privileges of reservation, and the others would be known as non-creamy layer. This kind of a thing was answered by the Indira Sahni judgment. The third question was about what is now the important part which I want to develop for you, which is regarding this. Question number 4 in the Indira Sahni was, does the Constitution provide for purely an economic, does the Constitution provide for purely an economic basis of reservation? This was the most important question made in the Indira Sahni judgment, because as you can see that the reservation policy of the 1991 government gave a point about the question of what you can call reservations on the basis of only economic criteria. Okay, so all the categories of reservations that we see today are based upon some kind of a social criteria. Okay, some kind of a social criteria that you have, for example, a group of people who have been marginalized historically, a group of people who have lived away from the urban life, a group of people who have been found to be backward because of the policies of reservations, etc., etc. So these are all sociological entities, but the Constitution is not clear about mentioning any kind of a purely economic activity happening at the level of reservation. So the answer which was given by the Indira Sahni judgment over here was that no, the Constitution does not provide for any purely economic reservation, and therefore it struck down the EWS. The Constitution does not provide for any economic basis of reservation, and it struck down the EWS as unconstitutional. And it says that there is no provision of a purely economic basis of reservation, but also it implied that the Constitution does not provide under Article 15 or Article 16 any specific category based upon only purely economic grounds of a person. Okay. So, what you basically see is that the Article 15 and Article 16 do not provide for purely an economic basis of reservation, but it said that if it wants to make a case for it, the government can amend Article 15 and 16, and Article 15 and 16 can be amended to introduce EWS in the Constitution. But unless it is introduced in the Constitution by a Constitution Amendment Act of the government, it cannot be made a part of the reservation policy, because the Constitution as it stood in 1990 did not provide for a purely economic basis of reservation. All the basis of reservation in terms of determining categories for reservations were made in sociological aspects. Clear? Those were the 4 important judgments made by the Indira Sahni case. I'll repeat them for you. It was in 1979 that the Mandal Commission, the concept of the OBC was used to collect all the backward classes which were mentioned in the Constitution. The 1990 reservation policy gave effect to the Mandal Commission report, and it gave reservations the way that I had listed them over there. 27% to the OBCs, 22.5% to the SCs and ST combined, 10% to the EWS. But the EWS was not a part of the Mandal Commission. It was introduced by the government. Okay. Now, the government policy was challenged before the Supreme Court in the Indira Sahni judgment. Okay. And the Indira Sahni judgment gave answers to 4 questions, and Indira Sahni is a landmark judgment. It's a 9-judge Constitution Bench judgment, which can be overturned only by 11-judge Constitution Bench judgment, right? And in the Indira Sahni judgment, the Constitution Bench said that 4 questions can be addressed. Number 1, is the OBC a valid category under the Constitution? It said yes. Under Article 15 and 16, OBC can be read. Then the second question was, is there a ceiling to the number of percentage of reservation that can be given maximum of the total seat? It said 50% of reservations can be given, but it is not a strict rule. In exceptional circumstances, the 50% mark can be breached, but more or less it has to be adhered to. Okay. The third question was, do the OBCs as a class all fall under the quota of reservations, or is there a distinction? It made the distinction between the creamy and the non-creamy layer, which I have later identified, that the 8 lakh rupee of family income was decided as a criteria for distinguishing the creamy and the non-creamy layer. And the fourth question, which was the most important question, which we are going to focus upon right now with regard to the EWS judgment, was whether the government has the ability to make a reservation policy purely upon economic basis. Let's say, for example, I am not given reservation because of the caste or the class that I belong to, but because of the economic status that I have only. There is no other contingency or condition which is required for reservation. Okay, and the answer that the Supreme Court gave in the Indira Sahni judgment, the 9-judge bench, was that EWS does not figure in the Constitution. There is no clear mention of economic criteria as being the sole criteria for giving someone reservations, to give reservations based only upon poverty. So it said that the policy cannot be made because the Constitution cannot be read into providing for economic thing, and it struck down the policy, the parts of the policy using doctrine of severability, till the part it gave the power to the state to create reservations for economic basis. Okay, these are the 4 elements of the Indira Sahni judgment which I am focusing upon because it is going to be relevant for the examination about the EWS judgment. Okay, so this I am moving forward now. Okay, now, in what you call the Maratha judgment that we were discussing, let me just make you read through another thing. The Maratha judgment, as for example what our friend is saying over here, that Raghavendra is saying that in some state it is higher than 50%. Let's say, for example, the case of Maharashtra, in which after adding the quota for the Marathas in the OBC, it exceeded the 50% ceiling. The arguments made by the state governments before the court was that the Indira Sahni verdict must be referred to a 11-judge bench for reconsideration, since it laid down an arbitrary ceiling which the constitution does not envisage, right? So the government of Maharashtra argued before the Supreme Court saying that the 50% ceiling does not have a scientific basis and it must be revisited by the Supreme Court of India. In a unanimous opinion, the court held that there is no need to revisit the case. The court said that the 50% ceiling, although an arbitrary determination by the court in 1992, is now constitutionally recognized. So the 5-judge bench in the Maratha judgment case reaffirmed the 50% rule of the Indira Sahni judgment and said that there is no way that it can be reconsidered, even if it is not having a scientific basis to it. It is now become a part of the constitution. Okay, so on the basis of this, because it violated the 50% reservation criteria ceiling, the judgment which was made by the quota which was made for the Marathas by the Maharashtra government is struck down because it violates the 50% limit. And therefore, as you are asking the question, it is possible that if some state governments having 50%, if the case goes to the court and if the politics can be sidelined, etc., the Supreme Court has recent history of striking the reservation policy which has more than 50% quota as struck down. Okay, so that's a part that I wanted to refer in the Maratha case also. Now this is again the case which has been given over here, which is the Maratha case, which is something that you can read over here, as you'll find it in the document also that we have attached over there. Okay, all right. Now we come to the current affairs which are immediately in our concern and vicinity, which is the EWS judgment. This is something that we have to pay some amount of clear attention to. EWS judgment. Okay, let me take for example a reference to the Constitution of India and see Article 15 and 16 just briefly. In the Indira Sahni judgment, the Supreme Court had said that there is no basis for giving reservations purely on economic terms because the Constitution does not provide for only an economic criteria for getting reservations. Right? Clear? So what the government did was, in Article 15 and Article 16 with regard to educational institution and with regard to what you can call government, with regard to educational institutions and government offices, for example, it introduced this clause. This is known as Article 16 clause 6. It says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes of mentioned in clause 4, in addition to the existing reservation and subject to a maximum 10% of the posts in each category. The 10% EWS policy, which was first introduced in the 1990 government order, was in a way made a part of the Constitution of India by amending the Constitution. You see the point? Supreme Court in Indira Sahni had said that there is no provision for making reservations based upon economy as a concept only because the Constitution doesn't provide for it. So what the Parliament did by this amendment in 2019, the Parliament started with the strong footing of making economic criteria introduced into the Constitution directly, right? Inserted in the Constitution by the 103rd Amendment Act 2019, economic criteria was made a part of the Constitution under Article 15 directly. Clear? So the limitation which was given by the Indira Sahni judgment was overcome by the Parliament by giving a direct introduction of the thing, and therefore, of course, this kind of a thing became a little bit of a foolproof. But nonetheless, the EWS, there was a case which went to the Supreme Court, which is known as the EWS judgment. Again, a 5-judge bench of what is also known as a constitution bench. It considered the question, number 1, that is the EWS judgment constitutionally valid. Okay. Now, first argument which was made to prove its constitutional validity was that yes, the Indira Sahni limitation has been met because the Constitution Amendment Act has been legally passed. All the judges agreed with it. Now the next question that was being asked with regard to EWS was, pay attention to this because this is going to be the basic crux of a question if it comes upon the EWS judgment, which is very likely to come because it made huge waves in the current affair department recently. Okay. The question that was asked by the 5-judge bench at this point was that when you talk about EWS quota for educational institutions under Article 15 and the public offices under Article 16, when you talk about the EWS quota under educational institutions in Article 15 and public institutions of offices in Article 16, it also mentions that anyone who has availed reservations as an SC, ST or OBC previously shall not be eligible for reservations as a EWS. Okay. This was a condition which was given under Article 15 and under Article 16 again. I'll repeat it. Anyone who has made, what the particular part says, that any person who has attained reservations as an SC, ST or OBC will not qualify under EWS. So let's say, for example, the criteria which was given by the Government of India for EWS was 8 lakh annual family income plus some property requirements. Okay. Any person who has a family income below 8 lakh rupees and also is not getting any reservations under these categories shall be eligible to get reservations as an EWS under Article 15 clause 6 and Article 16 clause 6, which have been introduced into the Constitution by the 103rd Constitution Amendment Act 2019. This is what Article 15 and 16 say. Now, the challenge to the constitutional validity was like this. A challenge was made that the provision of giving it not to these people is a violation of Article 14, which includes equal protections of the law and equality before law. So this was a argument which was made before the court, that if you are saying that economy should not be a criteria, a caste should not be a criteria for reservations, there must be a purely economic criteria in terms of your poverty matrix, etc. Reservations can be given to you. The question that was asked for the Supreme Court is that why is caste becoming a disqualification? Let's say, for example, if a person is taking reservations as a scheduled caste, and what the government is saying that caste is not the only criteria for reservations, then why are you disqualifying people who have taken reservations as a certain particular caste from reservation under the EWS? Okay. It was a kind of a solid challenge made by the petitioners in this case, stating that giving a kind of a policy objective in which people are disqualified from getting certain benefits because of their caste is a violation of Article 15 of the Constitution. Okay. Now, what it basically says is that if you are giving only on the basis of economic conditions, nothing else is considered, nothing else is looked into, but only on the basis of economic conditions of a person. But if you are disqualifying people who are of a particular caste, then you are making a discrimination and violating Article 14 of the Constitution, right to equality before law and equal protection of the law. Right. This was a challenge which was made to the EWS quota, but the bench with a 3:2 majority held that the ground which was made over here was not sustainable, and it held the constitutional validity of the 103rd Constitution Amendment Act 2019, and said that in no account does the exclusion of the SCs, STs and OBC amount to what you can call a reservation, a violation of Article 14 of the Constitution. Right? This was a judgment given by the majority bench, but the minority bench, which included the Chief Justice of India, held that the judgment given, the Constitution Amendment 2019 was in violation of the right to equality, and which was a basic structure of the Constitution of India, and therefore it ought to be struck down because it was making a discrimination and not giving economic advantages or economic reservations to everyone regardless of their caste. And therefore it was conducting a kind of a discrimination, and they wanted to declare it as unconstitutional. But since they were in a minority, the majority judgment had their way and said that the EWS reservations made by the Government of India in the 103rd Constitution Amendment Act is completely and comprehensively constitutionally valid. It does not suffer from any kind of a disqualification or any kind of a limitation in terms of its constitutional categories. Okay. Another question which was considered in the EWS case was that the 50% mark given by the Indira Sahni judgment is what you can call breached by introducing EWS as a category. As you can see that both for Article 15 and Article 16, the maximum percentage of reservations, both for Article 15 and Article 16, the maximum percentage of reservations was given in the EWS category up to a 10%, not more than 10%. It is constitutionally written there that the EWS reservation cannot exceed 10%, right? EWS reservation cannot exceed 10%. It was given in the what you can call the Constitution itself, Article 15 clause 6 and Article 16 clause 6. Just for your reference, please be sure about memorizing this. 10% is a cap which has been attached to EWS quota. But the introduction of the 10% EWS quota inevitably led the reservations to breach the limit of 50%. So another question which was posed before the Supreme Court was, does the EWS quota violate the Indira Sahni judgment of 50% ceiling, in which the court said that the 50% ceiling was not sacrosanct and it can be breached in certain cases, etc., etc. So what you have basically is that in 2 years you have two constitution bench judgment by the Supreme Court. One in the Maratha case, in which the Supreme Court had said that the 50% rule is an inherent part of the reservation policy. But another in the EWS case, in which the Supreme Court said that if the 50% mark is breached, it is not the unconstitutionality of that degree which is going to be very sacrosanct. Okay? And therefore, this kind of a judgment finally made the way for the EWS judgment. EWS as a Constitution Amendment Act, a firmly stated principle of the Indian Constitution under Article 15 clause 6 and Article 16 clause 6. Please remember that the maximum amount of reservation which can be given under the EWS category is 50%. Not more than 50% can be given under the EWS category as reservation. Clear? Okay. Now, another question that we have to address at this point of time is that how does the government decide what group of people fall under the EWS, right? Let me go back to the structure. Okay. If I ask the question with regard to SC, you can make a very clear chart over here. You have Article 338, you have Article 341, right, which is the National Commission for Scheduled Caste and the Government of India at the Union. If we are asking with regard to ST, you have Article 338A and Article 342. With regard to OBCs and SEBCs, again the matter is sorted. You have Article 338B and Article 342A. These are two articles which are the crux of the Maratha judgment which we have discussed. Okay, but what happens with regard to SEEWS? The question is there a constitutional body which is governing the criteria for EWS? For example, we have the 8 lakh annual income criteria. We have the 8 lakh annual income criteria for the EWS, right? How do you determine this criteria? ये क्वेश्चन आ सकता है प्रीलिम्स में बहुत सिंपल तरीके से कि क्या ये क्राइटेरिया कॉन्स्टिट्यूशनली डिटरमाइंड है? क्या संविधान में जैसे नेशनल कमीशन फॉर बैकवर्ड क्लासेस है, नेशनल कमीशन फॉर शेड्यूल्ड कास्ट्स है, नेशनल कमीशन फॉर शेड्यूल्ड ट्राइब्स है, क्या नेशनल कमीशन फॉर EWS है क्या? For economically weaker section. Now we have seen Article 338 to 342A. There is no such mention. The introduction which made Article what you can call 16 clause 6 and 15 clause is a part of the Constitution did not make a subsequent corresponding introduction in the articles which refer to the national commissions. So the simple answer is that there is no constitutional body yet in place which gives the power to the government of India to recommend or to have a kind of take recommendations from that constitutional body. Also correspondingly, there is no explicit power given to the president and the parliament for the allocation or the notification of who is going to be EWS. So this is a little bit of a grey area which the government has not been able to give an answer to. First of all, how do you determine the 8 lakh criteria? Okay. Now the current answer to that question which was submitted by the government before the Supreme Court. Supreme Court recently asked this question in the middle of the NEET counselling. Supreme Court said that how do you say that the 8 lakh criteria was, what kind of a scientific evidence have you referred to in terms of saying that the 50% criteria which is given by the EWS is, let's say for example, valid. Okay. So for example, here you have this kind of a question comes in the NEET counselling every year. The medical entrance examination NEET, in which the government is supposed to give a kind of a percentage of reservation for the admissions into medical colleges. And since the EWS quota was in application, the government gave a 10% reservation for EWS. Now a few people went to the Supreme Court filing an application and asking the question, what is it that makes the government determine 8 lakh as the criteria for determining who an EWS is? For example, some person would say that just because I am earning less than 8 lakh, or let's say 8 lakh 5,000, I am moved away from EWS. Someone has 7 lakh 99,000, he's moved into EWS. So what is the basis of this rationality? What is the science behind this logic? Okay. So this is the same question that the Supreme Court was asked by a petitioner, and the Supreme Court in turn asked this question to the Attorney General, to the Government of India. Okay. Okay, so this was a question that the Supreme Court had asked. Now the answer which was given by the Government of India was that there is no constitutional body which is appearing in the picture which takes cognizance of what are the conditions under which a person can be given EWS criteria. मतलब 8 लाख को decide करने वाली कोई constitutional body नहीं है. Okay. The government gave the answer in this particular case, that, which is again going to be important for your prelims examination, that the determination of EWS is to be done by a committee which is made under a Department of Social Justice. Department of Social Justice under the Ministry of Social Justice. So you have the Ministry of Social Justice, and within the Ministry of Social Justice you have a Department of Social Justice. Okay, we have Ministry of Social Justice, and you have a Department of Social Justice, and the Ministry of Social Justice is in control of the Department of Social Justice, and the Department of Social Justice appoints a committee which is known as the EWS committee. So you can see this is a non-statutory body. It is appointed by the ministerial level, right? It is appointed at the mantri level. Neither the parliament nor the constitution has the power to appoint a body over here. It is the minister. Any prime minister can give a simple rule that this body is going to judge the criteria for determining 8 lakh annual income criteria, right? And currently the chairman of this committee is a person by the name of Ajay Bhushan Pandey, and therefore it is also referred to as the Ajay Bhushan Pandey committee. It is the Ajay Bhushan Pandey committee which has in a way identified the 8 lakh annual income criteria as a standard for the allocation of the category of EWS to any particular person. So this kind of a situation is what we are taking a look at in terms of getting a sense of how the entire EWS position and points are rotated. Okay, let me just repeat to you the entire structure. You have article, let me just draw it back again, reservations. I think this kind of a crash course upon this very important topic which was there in the current affairs would put you in better stead to solve the prelims based question on the reservations part. Okay. You have article 15, you have article 16, talks about education, reservations in educational institutions, reservations in what you can call economic government offices. Okay. Then you have after that article 338 and article 341. It talks about the National Commission for Scheduled Castes and the policies, the power of the President and the Parliament to notify scheduled caste on the recommendations of the National Commission for Scheduled Caste. Then you have article 338A and 342 with regard to scheduled castes, scheduled tribes, sorry. Then you have article 338B and 342A with regard to OBC and SEBC. Then you have, for example, the committee which is I have mentioned as the Ajay Bhushan Pandey committee. Okay, this can be a direct question in the prelims examination because sometimes the important committees are asked, and the Supreme Court has already given a judgment on the EWS, so this committee can be given. This gives recommendation to the Government of India, which currently notifies the EWS. But nonetheless, this reservation is not only at constitutionally is not given under what you can call the Government of India, which basically means President and Prime Minister is not given the constitutional power to determine who an EWS can be, and it is open for the states to stake a claim on determining EWS for their particular states. But that point is still under development. Okay. Apart from this, you've taken a look at the Mandal Commission, the recommendations made by the Mandal Commission, the challenging of the reservation policy based upon Mandal Commission in the 9-judge constitution bench known as the Indira Sahni versus Union of India 1992, and the observations made by Indira Sahni, 4 observations importantly. And then you've taken a look at the questions which have been asked with regard to the EWS amendments, right? The 2019 Constitution Amendment Act, which introduces the EWS, was challenged before the Supreme Court for constitutional validity, but the Supreme Court upheld the constitutional validity of the EWS, stating that there was nothing wrong with the way in which the Parliament had done it, and also it did not violate Article 14 of the Constitution, as it was a basic structure of the Constitution, just by not giving reservations to people who had already claimed reservations under the category of scheduled castes, scheduled tribes and other backward classes. Clear? Okay. So I think this kind of a thing is one thing that we have covered, a very important part of the current affair which I wanted to take a clear shot at. Take. You just have a glass of water. Okay, now let me for example give a kind of a little bit of a what you can call a revision of how what points are there that you can remember for your reference. Question to you: can a state government, let me see some activity on the chat box over here. I'm asking certain questions with regard to what you've covered right now, and just give me an answer in yes or no. I'd like to see some activity in the chat group. Okay, my question is very simple: can a state government determine the group of people who can be introduced in the category of a scheduled caste? Yes or no? What is the answer to this question? Can a state government determine the group of people who will be introduced in the category of scheduled castes? Yes or no? Let me see some activity here. Let me see if you can give the answer to this one. It was a very kind of a prelims based kind of a thing. Again, let me repeat it. Can a state government give introduction to a particular group of people as a scheduled caste? Yes or no? Great. Can you give me the relevant reasons for it? One reason is that there is a National Commission for Scheduled Castes, which is a constitutional body, and the other reason is Article 341 of the Constitution, which gives the power to the President and to the Parliament, but it does not give the power to the government of the state at all. Very good. Good to hear responses. Okay, next question. Think of this as a proper answer and tell me. Before 2018, could the state government give the allocation of other backward classes seats to groups within their states only in matters of educational institutions and public offices which were administered by the state government? Before 2018, could the state governments give matters with regard to OBC reservations to groups of people in public institutions, educational institutions and offices run by the state government? Yes or no? Yes. You see, a prelims question can be a little bit rounded off, which is before 2018, as I discussed, the power to notify OBCs was also given to the state government. It was only after the introduction of Article 338A, National Commission for Backward Classes, and introduction of Article 342A, a National Commission, the powers of the union government, executive and legislature, were these powers curtailed. Now, if for example, if I ask you the Supreme Court judgment which gives the power, which gives the authority, let's say, or gives a validation to the power of the union to notify the OBCs. Can you name the judgment for me, the Supreme Court judgment, which was recently passed? Let's say if a question is, which of the following recent Supreme Court judgments ascertained the powers of the union to notify OBCs for the entire territory of India? Can you give me the name of the judgment in the chat? Can you give me the name of the Supreme Court judgment which is relevant in this regard? Very good. The Maratha OBC reservation judgment. It was declared unconstitutional, the introduction of the Marathas into the other backward classes, as it violated the 50% ceiling limit, and also it was not under the control of the state government to notify OBCs anymore, because that power was given to the union government under Article 338A and Article 342A. Okay. ठीक है. Okay. Another question to you. With regard to, I'm just asking a question and then I'll give you an option and you tell me what can you write in that. With regard to the recent judgment given by the Constitution Bench of the Supreme Court in the EWS quota case, which questioned the constitutional validity of the 2019 Amendment Act. Which of the following grounds was the constitutional validity of the 2019 CAA challenged? Which of these are grounds upon which it was challenged? A. State could not make EWS policy by disqualifying SCs, STs and OBCs. Okay? SCs, STs and OBCs. And B, the Constitution explicitly prohibits, the Constitution explicitly prohibits a purely economic criteria for reservations. ठीक है? Out of A and B, which is a ground upon which the 2019 CAA was challenged? Which is a ground upon which the 2019 CAA was challenged, between A and B? What do you say? Between A and B, which was a ground upon which the CAA was challenged? Yes, that's the point, that now some of you are making an error. The Constitution does not explicitly prohibit purely economic criteria for reservation. The Constitution is silent. It does not provide, but it does not prohibit. Meaning, there is a vacuum. There is not a negative. इंदिरा साहनी में कोर्ट ने कहा था कि यहाँ पर कुछ लिखा नहीं है इस तरीके का, तो जब तक आप लिख नहीं देते तब तक हम इस पे जजमेंट नहीं बना सकते. मतलब अनलेस यू राइट इट इन द कॉन्स्टिट्यूशन वी कांट गिव यू जब तक आप संविधान के अंदर इसको आप लगा नहीं देते तब तक आप पॉलिसी कैसे बना सकते हो? तो पहले आप संविधान में लगाइए. तो इंदिरा साहनी की जो रिक्वायरमेंट थी वो पार्लियामेंट ने फुलफिल कर दी कि संविधान में डायरेक्टली लगा दिया उसको, इस वजह से उसकी कॉन्स्टिट्यूशनल वैलिडिटी चैलेंज नहीं हो सकती थी। लेकिन संविधान में कहीं भी ऐसा लिखा नहीं है कि प्योरली इकोनॉमिक बेसिस पे कोई रिजर्वेशन नहीं दिया जा सकता। इट डजंट प्रोहिबिट दैट काइंड ऑफ अ थिंग, इट जस्ट डज नॉट प्रोवाइड फॉर इट, है ना? समझ रहे हैं ना आप इस बात को? इसको थोड़ा सा ध्यान में रखिएगा इस चीज़ को ना। ये इस तरह के क्वेश्चंस, थोड़े घुमावदार क्वेश्चंस आपके बन के आपके सामने आ सकते हैं। ठीक है, अब आप लोग एक काम कर सकते हैं, जस्ट फॉर योर रेफरेंस सेक, जो हमने आर्टिकल्स लिखे हैं यहाँ पर, आर्टिकल 15, आर्टिकल 16, आर्टिकल 338, आर्टिकल 338 ए, 338 बी, 340, 341, 342, 342 ए, आपका थोड़ा सा भी टाइम अगर आपको मिले तो आप इन आर्टिकल को कॉन्स्टिट्यूशन के बेयर एक्ट से डायरेक्टली पढ़ लीजिएगा। कॉन्स्टिट्यूशन का बेयर एक्ट मैं आपको PDF के फॉर्मेट में आपके पोर्टल्स पे अपलोड करवा दूंगा। अगर आपको थोड़ा सा टाइम मिले, बहुत ज़्यादा मुश्किल नहीं है इन चीज़ों को पढ़ना, just go to these article and try to read the language of these articles, है ना? और एक बार आप इसको पढ़ेंगे तो आपको पूरा जो reservations का खाका है, पूरा entire structure of reservations will be absorbed into your mind. Past and present and current, any question from reservations, affirmative actions, you can take a look at these articles and you'll be satisfactorily able to answer them. ठीक है? Yes, so Anupama is absolutely correct in what she's pointing out, that there is no explicit prohibition in Article 15 and 16. But just for your sake of reference, I am telling you, go after this session sometime, you please go and read Article 15, 16, 338, 338A, 338B, 340, 341, 342, 342A, once from the Constitution directly. उसके बाद आपको किसी किताब को पढ़ने की जरूरत नहीं, और इंदिरा साहनी पे और जो मराठा जजमेंट और EWS, 3 इंपॉर्टेंट जजमेंट्स है, उनके नोटिफिकेशन हमने ऑलरेडी ले लिया। अजय भूषण पांडे कमेटी का नाम मैंने आपको बता दिया, इससे बाहर से आपका रिजर्वेशन का कोई भी क्वेश्चन नहीं आएगा। डायरेक्टली फ्रॉम द व्हाट यू कैन कॉल द कॉन्स्टिट्यूशन और फ्रॉम द करंट अफेयर्स, हमने सारा इसमें कवर कर लिया। ठीक, आशुतोष मिश्रा जी कह रहे हैं, सर डज स्टेट कैन नोटिफाई द लिस्ट ऑफ SC and ST? नो। आर्टिकल 338 and Article 341 read together gives all the power to notify SCs and STs to the union government, union parliament and the union executive. ठीक है? ठीक है, आप में से कुछ लोग आर्टिकल 105 की बात कर रहे हैं, तो मैं अमेंडमेंट ऑफ आर्टिकल 105 LD चरण, आई रिमेंबर यू फ्रॉम जयपुर, आप जो पूछ रहे हैं वो ठीक है, आई जस्ट टेक अ लुक एट इट, जस्ट बिकॉज यू आस्क, आई विल क्लैरिफाई अपॉन द 105th अमेंडमेंट एक्ट मेड इन द कॉन्स्टिट्यूशन. It's good to see some of the familiar names in this session. Maybe this draft of the constitution doesn't have the updated version. Just give me a time in the break. LD, I'll get back to this question with regard to the 105th constitution amendment. Maybe it's not updated in this draft. Just let me pull it out during the break and I'll clarify upon that. And I'll be sure to tell you that it doesn't give the power to the state to identify the OBCs. It just kind of makes a very simple non-binding obligation on the union to consult the state in some kind of a manner. Okay, but all said and done, there is no power given to the state for any kind of identification. Okay. Garima has a question. Parliament voluntarily moved the motion to add caste to SC list, or it can only proceed after recommendations of the NCSC? It's a very good question. Parliament cannot initiate the process of identifying a caste as an SC or ST or OBC. Okay, that's the point. Very detailed reading of the articles will tell you that though the President and the Parliament have been given the same power of adding and removing the lists of SC, STs and OBCs, but the process can only be initiated by the President. It cannot be initiated by the Parliament. If the Parliament wants to add a particular person as an SC or an ST, it cannot be done by the Parliament unless the process of doing that is initiated by the President. So President has to create the first list based upon the recommendations of the NCSC, right? So NCSC gives the recommendations to the President. The President may or may not, based upon the recommendations, identify the caste as an SC or an ST, and then give the list to the Parliament, and the Parliament can modify it then. But unless the President takes the initiative, the recommendation of the National Commission and the activity of the Parliament cannot have any value for him. The National Commission can give more and more recommendations to the President, but the President, if it is not willful for him to do it, he will not do it. So the real power in this particular case lies with the Parliament. With the President. Yes, as you are pointing out correctly, Sayan, the Parliament has only a kind of a review power. It cannot initiate a process unless the President wants it. Clear? Chalo, theek hai. Now this is done under Article 15 and 16. Moving forward, I think you get a sense of the way in which I am giving agendas to this. Article 17 of the Constitution and Article 18 of the Constitution are more or less easy to understand. We'll just revise them once. Article 17 says that there has to be what is called the untouchability in all its forms is abolished, and its practice is an offence punishable by law. It's all that it basically says, right? And Article 18 talks about abolition of titles. Right? It gives a sense of what forms of titles are there and what are abolitions of these things. So I think if you've covered classroom sessions with me, I've given you a very clear list, which is going to be a point, a good understanding of how the abolition of title and abolition of untouchability work in India. Right. So just to give a structural clarity, you have Article 14 to Article 18 dealing with what is known as the category of right to equality. Let me repeat it again. You have Article 14 and Article 18, which we are dealing with the category of right to equality, and we have dealt with this. Specific reference to Article 14, equality before law, equal protections of the law, Article 15 and Article 16 with reservations, a huge chapter upon it, and Article 17, Article 18, I expect that you can read it upon yourself. Now we come to the next category of fundamental rights, which is known as right to freedom. Very important category, right to freedom, and some amount of current affairs to be covered herein. Right to freedom. Right to freedom starts from Article 19, goes to Article 20, Article 21 and Article 22. Article 19 talks about freedom of speech and expression, etc. Freedom of speech and expression. Article 20 talks about freedoms from wrongful criminal action. Article 21 is the most important article in the Constitution, perhaps, provides for no person shall be deprived of life and liberty except by the procedure established by law. So here I will just give you a sense of what is the meaning of procedure established by law, because sometimes in the prelims you can have a question on the procedure established by law and the concept of the due process of law, the comparison between the procedure established by law and the due process of law. Okay, so this is a part that we can take a look at later on. So you have Article 19, 20, 21 and 22, which are known as the four freedoms. Okay, and 22 is of course some rights given to rights against detention, right, which basically includes the habeas corpus, etc., etc., and also includes the exception of the Preventive Detention Act. But my major focus is going to be upon Article 19 and Article 21 in terms of covering the current affairs. Briefly, let me take up Article 20 just to give you a sense of it. Article 20 clause 1 states that these are all 4 articles of freedom. Article 19 to 21 are articles which are known as right to freedom. The second category of fundamental rights after Article 14 to Article 18, which is the right to equality, in the first category of fundamental rights. Okay. Now, in the articles which are mentioned, I'll just give you a very brief revision of Article 20. Article 20 basically talks about right to freedom against a criminal action, and it constitutes 3 forms of criminal actions against which one requires a constitutional safeguard. One is known as the ex post facto law. Okay, ex post facto law simply means ex post facto law. If this is a question in the prelims, you just have to understand ex post facto law simply means that one cannot be punished for a crime, or one cannot be punished for an act which he has committed today, but has not been described as a crime by a law on the date of its commission, but has only been described as a crime by the law after the date of its commission. So the retrospective impact of a law which determines something as a crime is something that no person can be subjected to. ओके, तो अगर मैंने आज कुछ किया है लेकिन आज के दिन वो करने में आज किसी भी विधि के अनुसार वो गैर कानूनी नहीं है या फिर वो ऑफेंस नहीं है, मतलब पनिशेबल नहीं है, लेकिन मेरे करने के बाद मुझे पनिश करने के लिए विशेष रूप से मेरे को जेल में डालने के लिए उस एक्ट को क्राइम बनाया गया है, तो इसको कहेंगे प्रिवेंटिव एक्टिविटीज अगेंस्ट एक्स पोस्ट फैक्टो लॉ. जैसे ब्रिटिश साम्राज्य में ही होता था, कोई बहुत महान पॉलिटिकल लीडर अगर भारत में कुछ कर रहा होता था, जैसे बाल गंगाधर तिलक ने कुछ किया, तो ये है कि बाल गंगाधर तिलक ने कुछ किया मान लीजिए और वो कानून के अनुसार गलत नहीं है, लेकिन सिर्फ बाल गंगाधर तिलक को जेल में डालने भर के लिए ब्रिटिश सरकार वो कानून में गलत बता देगी और फिर रेट्रोस्पेक्टिवली मतलब पुरानी डेट बैक डेट करके उसको उसमें लगा देगी. तो इसको एक तरह से मतलब रोकने के लिए जो भारत का संविधान है उसने आर्टिकल 20 क्लॉज 1 में एक्स पोस्ट फैक्टो लॉ का प्रोविजन डाला हुआ था. ठीक है, तो ये एक जो पॉइंट है ये आप थोड़ा सा ध्यान रख सकते हैं. फिर दूसरा है डबल जेपर्डी. ठीक है, डबल जेपर्डी का क्या अर्थ होता है? डबल जेपर्डी का अर्थ होता है कि कोई भी एक व्यक्ति एक ही क्राइम के लिए 2 बार जेल सेंटेंस नहीं कर सकता है. ठीक है, नो वन पर्सन कैन बी punished twice for a similar crime. Clear? That's double jeopardy. एक बार पनिश कर दिया उसको, पनिशमेंट पूरा कर ले तो दोबारा उसको नहीं किया जा सकता. और तीसरा है राइट अगेंस्ट सेल्फ इंक्रिमिनेशन. राइट अगेंस्ट सेल्फ इंक्रिमिनेशन का अर्थ होता है कि आप जैसे बिल्कुल सिंपल अर्थ ही होता है राइट अगेंस्ट सेल्फ इंक्रिमिनेशन का 20 क्लॉज 3 में कि नो पर्सन कैन, मतलब जैसे मान लीजिए आपने अगर पुलिस के सामने कोई बयान दिया, ठीक है, और पुलिस ने आपके बयान को आप जैसे मान लीजिए आपको पुलिस पकड़ने आई सामने आपके और आपको पुलिस ने पकड़ के डरा के आपसे कुछ लिखवा लिया या आपसे कुछ बुलवा लिया, रिकॉर्ड कर लिया मोबाइल पे कि आपने ये गुनाह किया है. अब आर्टिकल 20 क्लॉज 3 के अंदर क्या है कि अगर पुलिस ने आपसे कोई बयान लिया है तो वो बयान किसी भी कोर्ट के सामने एविडेंस की तरह मान्य नहीं होगा. खास तौर पे अगर उस बयान में आप कबूल कर रहे हैं कि मैंने कुछ किया है, क्योंकि एक बेनिफिट ऑफ डाउट दिया जाता है आपको कि पुलिस ने आपसे डरा धमका के आपको डरा के आपसे कुछ उगलवा लिया होगा, इसीलिए उसको एविडेंस के रूप में नहीं मान्यता दी जाएगी. एनी काइंड ऑफ अ स्टेटमेंट मेड बाय यू बिफोर द पुलिस और एनी अथॉरिटी एक्सेप्ट द मैजिस्ट्रेट कैन नॉट बी टेकन टू इंक्रिमिनेट योर ओन सेल्फ अंडर आर्टिकल 20 क्लॉज 3 विच इज राइट अगेंस्ट सेल्फ इंक्रिमिनेशन. दैट इज द पॉइंट दैट वी आर लुकिंग एट ओवर हियर. ठीक है, चलिए नाउ let me move on to the next important part, which is article 19 of the constitution. article 19 1a. ठीक है, तो article 19 का थोड़ा सा इंट्रोडक्शन आप लोग ऑलरेडी ले चुके हैं पहले क्लासेस के अंदर कि article 19 is freedom of speech and expression. ठीक है, article 19 का मतलब है freedom of speech and expression. एंड आर्टिकल 19(1)(a) कहता है कि एवरी पर्सन शैल हैव द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. सॉरी, इट इज गिवन एज अ राइट ओनली टू सिटीजन्स, नॉट टू पर्सन्स. ठीक है, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. और आर्टिकल 19 क्लॉज 2 क्या करता है और फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन को कर्टेल करने की कंडीशंस बताता है। अंडर व्हाट कंडीशंस कैन द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन ऑफ अ सिटीजन बी कर्टेल्ड। तो पहले तो आप देखिए कि अगर कोई बाहर देश का नागरिक इंडिया के अंदर रह रहा है तो उसके ऊपर कोई फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन नहीं लग सकती है। कारण ये है क्योंकि वो सिटीजन नहीं है। तो अगर उसको कोई अभिव्यक्ति की आज़ादी देने की बात होती है तो वो मना किया जा सकता है स्टेट के द्वारा, क्योंकि वो पर्सन है, वो सिटीजन नहीं है। ठीक है, तो आर्टिकल 14 जैसे सिटीजन्स पर लगता नहीं है, पर्सन पर लगता है। आर्टिकल 19 सिर्फ सिटीजन्स को दिया जाता है। ये एक इंपॉर्टेंट पॉइंट है आपके प्रीलिम्स के लिए। अब आर्टिकल 19(2) क्या बोलते हैं कि इसमें कुछ कंडीशंस दे रखी हैं जिसके अंदर फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन किसी एक व्यक्ति की कर्टेल की जा सकती है, उसको काट के रख दिया जा सकता है। फॉर एग्जांपल पब्लिक ऑर्डर, मोरालिटी, डिसेंसी। आप आर्टिकल 19 क्लॉज 2 में ये सारी चीज़ें पढ़ सकते हैं। यू विल गेट अ सेंस ऑफ व्हाट इट इज़ बेसिकली इलैबोरेटिंग अबाउट। मैं जो चीज़ इसमें आपको थोड़ा सा समझाने जा रहा हूँ उसमें 2-3 चीज़ें कवर करने की कोशिश करूँगा। ठीक है, एक मैं कवर करूँगा व्हाट इज़ नोन एज a very legendary judgment by a Supreme Court bench, which is known as the Puttaswamy judgment, which also is the judgment which talks about right to privacy. ठीक है, उसके अलावा मैं कवर करूंगा जो डेटा प्रोटेक्शन बिल संविधान में पिछले कम से कम नहीं तो 5 साल से इधर उधर हो रहा है, और अभी फिलहाल में ही सरकार ने इसकी एक नई कॉपी पब्लिक के संज्ञान के लिए एक्सेस करवाई है। तो एक पर्सनल डेटा प्रोटेक्शन बिल था जो पहले इंट्रोड्यूस हुआ था, फिर उसको खींच लिया गया वापस, उसकी जगह डेटा प्रोटेक्शन बिल लगाया गया, फिर उसको खींच लिया गया, अब उसके जगह नया बिल लगाया गया। और एक कमेटी थी BN श्रीकृष्णा कमेटी, इनके बारे में थोड़ा मैं ऐतिहासिक रूप से आपको बताऊंगा कि इनका स्टेज इस समय चल क्या रहा है, मतलब ये पॉइंट किस पे पहुंचे हैं, जहाँ पर कि पर्सनल डेटा प्रोटेक्शन लॉ जो प्राइवेसी को एक सिक्योर करता हुआ लॉ है उसका स्टेटस क्या है, और जॉइंट पार्लियामेंट्री कमेटी इसमें क्या रोल निभा रही है। क्योंकि ये पॉलिटी से आधारित क्वेश्चंस कुछ हैं जो न्यूज़ में हैं थोड़े समय से। देयर आर सम क्वेश्चंस विद रिगार्ड टू पॉलिटी व्हिच आर सर्कुलेटिंग इन द न्यूज़ विद रिगार्ड टू द पर्सनल डेटा प्रोटेक्शन बिल। आई एम श्योर यू मस्ट हैव सीन सम editorials upon this yourself. So this is something that we'll cover, and then with regard to this we will also cover what is known as the information technology rules. Information technology rules ये भी थोड़े से न्यूज़ में चल रहे हैं पिछले 2-3 साल से। पहला जो सेट था इंफॉर्मेशन टेक्नोलॉजी रूल्स का वो आया था 2021 में, उसके बाद इसको अमेंड करके 2022 में कुछ रूल्स और लगाए गए थे, और अभी फ़िलहाल में ही 2023 में इंफॉर्मेशन टेक्नोलॉजी रूल्स में कुछ और एडिशन करके कुछ अमेंड्स किए गए हैं। तो दिस हैज़ बिन इन न्यूज़ रिसेंटली, एंड ऑल ऑफ दिस इज़ कमिंग आउट ऑफ आर्टिकल 19 विच इज़ 19(1)(a फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन। ठीक है, अलॉन्ग विद दिस आई विल डील विद सर्टेन एस्पेक्ट्स ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट। I will deal with certain aspects of the Information Technology Act 2000, which is the 2 sections that I will deal with are section 69A and section 79A. इनसे आपके प्रीलिम्स के कुछ क्वेश्चंस बनने की संभावना है, क्योंकि ये न्यूज़ में बहुत ज़्यादा सर्कुलेट हो रहे हैं। आज से नहीं, कम से कम 2-3 साल से, और पिछले वर्षों में जब इन पर न्यूज़ डेवलप हुई थी तो इन पर क्वेश्चंस नहीं पूछे गए थे। तो इसीलिए हम वी कैन मेक एन अजम्पशन दैट इन द कमिंग ईयर्स द क्वेश्चंस अबाउट द government of India, making these rules, etc., can come into picture over here. ठीक, okay, let us begin the analysis over here. One of the most important judgments which was given by the KS Puttaswamy judgment is that privacy is a fundamental right under Article 21 of the Constitution. अगर आप इस एक स्टेटमेंट को पढ़ लेंगे तो आपको पूरा पुट्टास्वामी का जो जजमेंट है वो समझ में आ जाएगा. पुट्टास्वामी के पहले भी privacy was considered a fundamental right. It was not that privacy was not considered a fundamental right. But before the Puttaswamy judgment, privacy was considered a fundamental right under Article 19 of the Constitution. But if you have a fundamental right which is under Article 19 of the Constitution, the fundamental right given under Article 19 of the Constitution is a very weak fundamental right, because the restrictions which can be imposed upon Article 19 are easily applicable. Article 19 clause 1 A, B, C, D, E etc. gives you the list of rights, but Article 19 clause 2 onwards gives you the restrictions which can be imposed upon those rights correspondingly. So Article 19 में जो rights दे रखे हैं weak rights दे रखे हैं, they are not very strong rights. State can take away your right to privacy in the case of a, let's say, public disorder or any kind of a what you can call any kind of a activity which is done to which can appeal to public morality or immorality, etc., etc. But once you put a right under Article 21, it is very difficult for the state to interfere in the exercise of that right, because Article 21 क्या कहता है? That no person can be deprived of their life and liberty except by the procedure established by law. There is only one condition under which a person's life and personal liberty can be deprived of, and that is a procedure established by law. Otherwise, a person has an almost absolute validity in terms of his life and personal liberty. Life means the right over one's body, and personal liberty means the right over one's mind. So the main argument made in the Puttaswamy judgment was whether privacy is a right as a fundamental right under Article 19 of the Constitution or under Article 21 of the Constitution. And the 9-judge bench held in the Justice Chandrachud judgment that privacy is a fundamental right. It is intrinsic to human life and it is intrinsic to human liberty, and it cannot be taken away except by a procedure established by law. And that procedure established by law is also reviewable under the Supreme Court, whether the Supreme Court can review the procedure established by law because of what is called the Maneka Gandhi case of 1978, in which the Supreme Court has said that a procedure established by law cannot be unjust, unfair or arbitrary. The Supreme Court can exercise a judicial review upon the question of whether a procedure established by the court, by the government, is just and fair and reasonable. Maneka Gandhi versus Union of India was a 1978 Supreme Court landmark judgment in which the Supreme Court said that the life and personal liberty of a person cannot be taken away by making an unfair, unjust or arbitrary procedure established by law. Okay, maybe if you read this, all of this will come highlighting back into your revisionary memory. So the judgment in the Puttaswamy judgment very simply said that the fundamental right of privacy is a fundamental right under Article 21 of the Constitution. Okay. Now, when the Puttaswamy judgment was being, authored, the biggest question that was coming was the question of Aadhaar. It was actually the Aadhaar case only. That Aadhaar was collecting, the UIDAI was collecting the biometric information upon individuals, citizens, etc. And then the question became that is it mandatory to give Aadhaar details to the government? And then this became the question of privacy. And then the question was whether privacy is a fundamental right under Article 19. If it is a fundamental right under Article 19, then the government can access the data without too much hassle, because there are reasonable restrictions to privacy if it is under Article 19. But the court held it is under Article 21, and the government cannot easily access the person's privacy or the Aadhaar card. The other issue which was coming together in this sense was the issue about what you can call the question of data privacy, which is becoming a big issue. Not only data collected by government, but also data collected by private organizations. As the quotation goes, data is the new oil, right? So that kind of a situation is something which the government wanted to, in a way, make data accessible, and private companies were taking data. So Supreme Court ने कहा, Puttaswamy judgment में ही, it directed the government to create a new framework of legislation which can be standard in terms of collecting data. मतलब अगर आप किसी का data collect कर रहे हो as a private organization or a public organization, you have to make sure that the data that you're collecting does not violate the newly invented right to privacy under Article 21 of the Constitution. तो आपको एक नया लॉ बनाना पड़ेगा जिसको कि आप डेटा प्रोटेक्शन लॉ कह सकते हैं, और वो डेटा प्रोटेक्शन लॉ एक स्टैट्यूटरी प्रोविजन क्रिएट करेगा जिससे कि किसी व्यक्ति का अगर डेटा चोरी होता है उसकी कंसेंट के बिना, तो उसकी राइट टू प्राइवेसी का वायलेशन माना जाएगा, और जो करता है उसको कॉन्स्टिट्यूशनल या फंडामेंटल राइट तोड़ने के बेसिस पे पनिशमेंट दिया जाएगा. ठीक है, तो ये जो जजमेंट था सुप्रीम कोर्ट का, इसमें सुप्रीम कोर्ट ने मिनिस्ट्री ऑफ इलेक्ट्रॉनिक्स एंड इंफॉर्मेशन टेक्नोलॉजी मेटी, इट गेव रिकमेंडेशंस टू द मेटी, एंड मेटी then appointed what is known as the B.N. Shri Krishna Committee. In 2017, late 2017, early 2018, B.N. Shri Krishna Committee was appointed, and the B.N. Shri Krishna Committee gave a draft of what is known as the Personal Data Protection Law, and it submitted the draft to the ministry. Okay, so let's say for example how this kind of a thing works. The Personal Data Protection Bill was formulated by the B.N. Shri Krishna Committee. You can call it the BNS committee. This kind of a question can come in the prelims again. Which committee was responsible for drafting the Personal Data Protection Bill? And it submits the draft copy to the METI, which is the Ministry of Electronics and Information Technology. This is METI, right? And the ministry is then responsible for presenting this bill to the parliament. Now, as you would have known from your readings of the Constitution, that the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha has the power that at the time a bill is being introduced into the House, it can refer the bill to what is known as a parliamentary committee. And in that very activity, the Parliament, the Speaker of the Parliament or the Lok Sabha referred the Personal Data Protection Bill to a joint parliamentary committee for a review. And the joint parliamentary committee is supposed to give the recommendations upon this bill. And the joint parliamentary committee produced this bill before the parliament, which was now translated not as Personal Data Protection Bill, but the Data Protection Bill 2019. And Data Protection Bill. Okay, so you have the PDP bill, which was introduced, PDP, let's say draft bill, which was introduced by the B.N. Shri Krishna Committee in 2018 to METI, and by 2019, by a review given by the Joint Parliamentary Committee, it had turned into Data Protection Bill. The term personal data protection had been removed. Okay. Now, at the later turn of events, what we have seen is that in 2022-2023, recently, the government of India has withdrawn this bill. The Data Protection Bill 2019 has been withdrawn by the government of India and has been replaced by a new bill, which is currently known as the new bill of 2023. Okay, and this is a kind of a thing that has been a little bit of a news, and I'm going to only make some very initial advertisements about it. Okay, which is basically, let's take a look at the current affair development upon this. Take a look at this particular point and maybe just get a sense of what is it that we are trying to understand here in terms of memorizing certain facts which can be relevant for the prelims examination. In the K.S. Puttaswamy judgment, the Supreme Court of India ordered in 2017 that the right to privacy is an intrinsic part of the right to life and personal freedom guaranteed by the Indian Constitution. This is Article 21. In the light of this judgment and concerns around how large tech platforms are handling the personal data of its Indian users, the Centre in 2017 set up an expert committee chaired by the retired Supreme Court Justice B.N. Shri Krishna to formulate a regulatory framework for data protection. The Sri Krishna Committee submitted its report and a draft for the Data Protection Bill to the Ministry of Electronics and Information Technology on July 2018. Okay, just a few set of facts that you have to remember. For example, the K.S. Puttaswamy judgment you have to remember. For example, a question can come that the Personal Data Protection Bill is inspired with which of the following landmark judgments of the Supreme Court. You have to write the answer, K.S. Puttaswamy. Of course, you have to remember the name of the B.N. Sri Krishna Committee. It is a question that has been asked in the mains examination previously and can also be asked in the prelims examination to some extent. Okay. The bill that was tabled by the ministry in Parliament over a year was, however, criticized by Justice Sri Krishna for giving much more control to the central government over the data than envisaged in the committee's draft. The government had changed its nature of the bill, and the changes were made in the bill by the Joint Parliamentary Committee. Its report in 2021, the provision that enables government agencies, etc. We don't have to go into this kind of a detail, but just know that the bill was then referred to the Joint Parliamentary Committee, and now at this point of time the bill has been withdrawn and a new kind of a bill has been introduced in its overhaul. As a kind of a new bill has been introduced in its overhaul. So the important points that we can remember about this particular instance is that there is a Supreme Court judgment which has in a way redefined the nature of privacy that is existing in India. Okay, the first thing that it says is that right to privacy is a fundamental right under Article 21. Second, on the basis of that, the committee was appointed which has given a kind of a draft bill, but the government has taken this draft bill to 2 or 3 layers, and still the government has not been able to pass the draft bill. So that is a kind of a conundrum which brings back the questions around K.S. Puttaswamy, Article 21 and right to privacy, and the B.N. Sri Krishna Committee relevant. So these are things that you can remember from the respect of the current affairs. Okay? Right to privacy not a fundamental right under Article 19 but under Article 21. Now the next important part that we are going to deal with regard to the government assertions are the information technology rules. Again, given in 2021, 2022 amended and 2023 re-amended. ठीक है, तो इसको थोड़ा सा हम अच्छे से categorically समझेंगे क्योंकि I have a very strong feeling this can be a question in the prelims examination this time. Okay, because it is in news for the last 3 years and this year it is extraordinarily in news because of some compliances default made by WhatsApp and Facebook and some court cases which are going in this particular sense. ठीक है, तो अब इसमें क्या है कि let me just give you a sense of it. Currently, the privacy of data or any kind of an activity which is happening on a computer in India is governed under the Information Technology Act. ठीक है, तो अभी जो पर्सनल डेटा प्रोटेक्शन बिल अभी पावर में नहीं है, उसके एब्सेंस में भारत के अंदर जो भी कोई कंप्यूटर रिलेटेड चीज़ होती है, इंक्लूडिंग द ब्रीच ऑफ प्राइवेसी और अ साइबर क्राइम, it is covered under the Information Technology Act 2000, which has been amended from time to time. ठीक है, now let me just draw a bit of a background to give you a sense of understanding about how the Information Technology Act is moving in a sense. Let me get a sense of that. Okay, so the Information Technology Act 2000 is the parent legislation currently which deals with all forms of issues related to a computer. Okay, and that is why the need for overhaul of the Information Technology Act is a kind of a impending need, because it is considered by many as outdated, because it was first drafted in 2000 and it has obviously not been able to catch up with the technological development which have happened. But the processes in the parliament with the personal data protection bill have been stuck, so this is still the parent legislation under which everything is governed. Now let me just tell you a story about an interesting fact which happened in the Information Technology Act. In 2005, in the year 2005, there was a case in India which is known as the Bazi.com case. This case just went to the Delhi High Court and the Supreme Court. Listen to this carefully and listen to it with the intent of making sure that you are able to answer some of the questions from the prelims examination in sense. So in 2005, the case which is known as the Bazi.com case, what was the facts of the case was that the social media platform known as Bazi.com was a platform on which auctions were made of certain objects. Let's say, for example, if you have let's say a glass or an antique thing or anything, you can post a picture of that particular thing upon the website Bazi.com, and then another person who wants to buy some amount of goods from Bazi.com, they can bid on buying that particular product, and therefore you can make that kind of a payment. So Bazi.com was like a social media platform from which products can be bought and sold between two people upon a bidding kind of a format. They had to make a kind of an auction upon this thing. That is why the name which was given to this particular thing was known as the Bazi.com. Okay. Now, one of the incidents which happened in 2005 with regard to Bazi.com was that a person from New Delhi had posted a pornographic clip of another person on the Bazi.com website, and the Bazi.com website was not able to filter it out for some reason. It didn't have the checks and balances around it, and another person in an auction bought that kind of a pornographic clip and downloaded it and circulated it. Now this matter went to the Delhi police. Delhi police filed an FIR against both the person who was putting the clip, the person who was buying the clip, but also the Delhi police filed an FIR against the CEO of the Bazi.com for letting this kind of an activity happen upon the social media platform. Okay. Now, the question that was now before a Delhi High Court, मतलब Delhi High Court के सामने जब मैटर गया तो Delhi High Court के सामने Bazi.com के CEO ने ये अपील रखी कि I should not be the one to face FIR over here, because I am merely providing a platform for other people to use. I don't have any movement in and out of the products. I just give a kind of a standard standing place over which people can give this kind of activity. So I just own the market, but I don't own the activities of the products which are exchanged in the market. So I should be exempt of this kind of a criminal charge that I was involved in creating pornographic material. The charges were framed under the Information Technology Act. Okay. The Delhi High Court said to the Bazi.com CEO that nothing doing, you have to be responsible for this kind of an activity, and the Delhi High Court sentenced the three of them for some amount of imprisonment for cyber pornography, etc., etc. Okay. So in this kind of a judgment of the Delhi High Court, it was held by the court that the intermediary, the social media intermediary, is equally responsible for the exchange of information on the platform that they are owning. Let's say, for example, if you are Amazon.com and if you're selling some amount of thing which is illegal, and if that kind of a thing breaches or breaks a certain law, अगर उसको में कानून व्यवस्था में कोई मतलब if it breaks a law somewhere or the other, then the argument which is made over here is that the Amazon.com is equally responsible as a person who's selling some illegal product and who's buying some illegal product in terms of breaking a particular law in reference to the Constitution, okay, in reference to the Indian Penal Code or something like that. Now, the Delhi High Court judgment in 2005 took about 7 years in 2012, in which the judgment of the Delhi High Court was appealed before the Supreme Court of India. the judgment of the Delhi High Court was appealed before the Supreme Court of India. And before the Supreme Court of India, the petition was made that the social media intermediary cannot be held responsible for the content which is exchanged. Social media intermediary cannot be held responsible for the content exchange on the platform. Cannot be held responsible for the content exchanged on the platform. And in 2012, the Supreme Court agreed with this proposition and released the CEO of Bazi.com. Saying that the platform should not have the responsibility or the criminality of hosting a certain particular kind of a content. It is merely a place where people interact with each other, and therefore the responsibility of the content should be limited to the people who are exchanging the content, not upon the social media intermediary. Okay? So in this sense, the Supreme Court made a kind of a judgment which radicalized and revolutionized the IT sector in India. And it was only after this judgment of the Supreme Court did it become possible for social media intermediaries like Facebook, WhatsApp, and whatever we were seeing in the day, Amazon, Reddit, all of these things to come and have great market access into the Indian IT sectors. Because then they got the immunity from the Supreme Court of India that anything which was happening upon their platform will not invite any kind of a criminal activity against them. In pursuit of this, the Parliament of India added a article, a section to the Information Technology Act, which is known as Section 79A. Now, this is a part of your questions, जहाँ पर आपके prelims में question आ सकते हैं, which is known as a safe harbor provision. Okay, safe harbor provision. Let's just take a look at Section 79A of the Information Technology Act to make the point clearly to you. Please read this, and read this as a sense that you may have to answer a question like this directly in the prelims examination. Under Section 79A of the Information Technology Act, what it is saying is that one second, just let me open. Yeah, sorry, just a little bit of a correction. This is not Section 79A, Section 79 of the Information Technology Act. Section 79 of the IT Act. This was introduced into the Information Technology Act after the judgment of the Supreme Court in 2012, in which the provision said exemption from liability of an intermediary in certain cases. Okay, so what it basically says that, you read this part, an intermediary shall not be liable for any third party information, data or communication link made available or hosted by him. Okay, now this is a section which is at the fundamental root of the success of the social media companies in India. Because what is basically it is meaning to say is that after the 2012 judgment, it became possible for the social media companies in India to have data move on the platform which is given by the social media companies without inviting any criminal complaint against themselves. Let's say, for example, if I am Twitter and if someone posts something pornographic on Twitter or something defamatory on Twitter, I have as Twitter a immunity which is given to me under Section 79 of the Information Technology Act. It says that An intermediary shall not be liable for any third party information, data or communication link made available or hosted by him. ठीक है, तो मतलब किसी भी तरह से अगर मान लीजिए कोई व्यक्ति कोई गलत तरीके की बात करता है सोशल मीडिया प्लेटफॉर्म पे, फेसबुक पे, ट्विटर पे, तो ट्विटर को एक इम्यूनिटी मिली जाती है जिसको कि सुप्रीम कोर्ट ऑफ इंडिया ने कहा था सेफ हार्बर प्रोविजन. इसको यू कैन ऑल्सो रिमेंबर इट एज अ नेम क्लियरली, सेफ हार्बर प्रोविजन. This is an immunity which is given to social media intermediaries in India under Section 79 of the Information Technology Act. Immunity given to the social media intermediaries in India under Section 79 of the what you can call the Information Technology Act, which allows them to operate without getting any criminality over them with regard to the content which is generating on the social media. ठीक है, अब ये बेसिकली एक पॉइंट हमारा कवर हो गया. ठीक है, तो सेक्शन 79A आप ढंग से याद रख लीजिएगा क्योंकि ये करंट अफेयर्स में डायरेक्टली आपके इंफॉर्मेशन टेक्नोलॉजी रूल से पूछा जा सकता है. नाउ इन द स्पेस ऑफ इंफॉर्मेशन टेक्नोलॉजी रूल्स मैं आपको थोड़ा सा समझाना चाहता हूँ. And the notes that I've attached to this are again going to be important for you to remember to read. Okay, information technology rules. Now, in India, a very simple assessment and assertion can be made about a particular fact. There are two kinds of institutions, public institutions. जैसे हम बात करते हैं कि एक प्रश्न अगर हम आपसे पूछें कि मीडिया को इंडिया में कौन रेगुलेट करता है, who regulates media in India, right? If that's a question that we ask, then the simple answer is that media is self-regulatory. मतलब मीडिया अपने आप को खुद को रेगुलेट करती है ना. मैं जैसे फॉर एग्जांपल अगर हम एक बात करते हैं कॉन्स्टिट्यूशन के अंदर, वी टॉक अबाउट अ कोड ऑफ ethics, something that you must have read in ethics sometime or the other, and what is known as a code of conduct. Okay, code of ethics and a code of conduct. अब कोड ऑफ कॉन्डक्ट का मतलब होता है कि मान के चलिए ये कोई पब्लिक ऑर्गेनाइजेशन है, जैसे कि मान लीजिए मीडिया है. Now let's say this is the government. Now if the media is trying to do something which is, let's say, in violation of certain ethics or laws, let's say, remember that example of what you can call the Sudarshan News. There was a media channel, satellite media, which had displayed certain aspects of certain things. For example, they had said about some coaching institutes doing certain things, etc., etc. So that kind of a publication by a media house is supposed to be a violative of a lot of laws in India and a lot of ethics in India. When the matter of Sudarshan News went to the Supreme Court said that we don't want to put media under state regulation. India has a kind of a principle in which media is self-regulated. मतलब मीडिया की क्या होता है कि जैसे for example you have the Press Club of India or the Press Trust of India. These are bodies made of the media houses themselves. These are bodies made of the media houses themselves who are trying to, in a way, regulate the conduct of the media. You have, for example, the Editors Guild of India. Right? So it is supposed to be a kind of a self-regulated, all the major media houses come together and form a body, and that body releases a code of ethics which has to be applied to all of them. It's a self-regulated kind of an activity that media is in India. A question which came in UPSC prelims once was whether media is regulated by the state or is self-regulated. The answer is self-regulated. It is not regulated by any law. There are censorship laws on movies and cinematographic acts, etc., etc. But there are no censorship laws upon the media in India. Okay. Similarly, when we talk about social media, there are no censorship laws upon social media also. Okay, the social media is not what you can call regulated by the state at all, at least up until the point of 2021. So let's say, for example, if someone posts something on Twitter which is offensive, which is also of a profane nature, okay, and let's say you find it offensive and of profane nature and you complain to Twitter. How do you complain it? You have an option of report abuse or something like that, and that kind of a data goes to Twitter. And then maybe Twitter takes a look at that data, maybe Twitter doesn't, maybe Twitter removes that account, maybe it doesn't, maybe the action is taken, it's not taken. You don't get any accountability as to what Twitter or Facebook or WhatsApp have done with regard to that particular data. Okay. So there is no what you can call enforcement or a law upon Twitter to take account of whatever has offended you and give you a response within this period of time. Right? If you have had any experiences of reporting abuse of anything, you don't know how and why and where these companies take their decisions of putting some content online or putting some content out of the picture. For example, Twitter, when it was very famous, had suspended the account of Donald Trump by the end of his presidential candidature because he was inciting riots in the Capitol building in the United States of America. Okay, so the question which was being asked over there was, how does Twitter take a decision of suspending an account of a person? At some point of time, there was a BJP spokesperson whose account Twitter has suspended and whose content Twitter has qualified as fake news, unverified content. तो क्वेश्चन ये पूछ रहे थे सब लोग कि ट्विटर अगर किसी एक अकाउंट को सस्पेंड करती है, किसी एक अकाउंट को टर्मिनेट करती है, किसी एक अकाउंट को बार बार गलतियों करने के बाद भी टर्मिनेट नहीं करती है, तो ट्विटर के पास क्या स्टैंडर्ड और क्या पॉलिसी जिसको फॉलो करके वो डिसीजंस ले रही है? और ट्विटर का आंसर ये था कि सोशल मीडिया इन इंडिया इज़ अ सेल्फ रेगुलेटेड एंटरप्राइज, नंबर 1। तो जो कंटेंट आ रहा है जा रहा है उसको हम अपने हिसाब से मैन्युफैक्चर करके, मतलब उसको अपने हिसाब से हम ट्रैफिक को ऑर्गेनाइज कर लेते हैं, हमारे खुद के कोड ऑफ एथिक्स हैं, ठीक है। और दूसरा, द सेकंड पॉइंट वाज ऑफ कोर्स समथिंग इनक्रिमिनेटिंग, अगर कोई क्रिमिनल एक्टिविटी ट्विटर के माध्यम से हो रही है, जैसे मान लीजिए किसी ने किसी का वीडियो बना के व्हाट्सएप पे डाल दिया, तो सेक्शन 79 ऑफ द इंफॉर्मेशन एक्ट के अंदर व्हाट्सएप को तो कोई टेंशन नहीं लेनी ना। They don't have to worry about anything under section 79 of the IT Act, because section 79 of the IT Act gives immunity to the social media platform from any kind of an activity which is happening upon their platform. So it was a very comfortable position for the social media companies. Number 1, they had no accountability about the content which was passing on their platforms. Number 2, they did not reveal to the world the standards that they were using to qualify and disqualify a content which was circulating on their platform. तो कभी भी किसी का अकाउंट सस्पेंड हो जाता था, किसी का सस्पेंड नहीं होता था, है ना, कभी किसी का ब्लू टिक निकाल लिया, कभी कुछ कर लिया, ऐसे ऐसे होता था। सो दिस बेसिकली लेट द गवर्नमेंट इन द एंड टू चेंज द लैंडस्केप ऑफ सोशल मीडिया फ्रॉम सेल्फ रेगुलेटरी टू गवर्नमेंट रेगुलेटरी, राइट? एंड दिस बिगैन द इंट्रोडक्शन ऑफ what you can call the information technology rules from the year 2021, which has now seen एडिशनल अमेंडमेंट। तो सरकार क्या करती है, अंडर द पावर्स गिवन टू द मिनिस्ट्री ऑफ इलेक्ट्रॉनिक्स एंड इंफॉर्मेशन टेक्नोलॉजी, ओके, अगेन दिस इज अ क्वेश्चन दैट कैन बी आस्क्ड, विच इज द नोडल एजेंसी फॉर इशूइंग द इंफॉर्मेशन टेक्नोलॉजी रूल्स? इट इज मिनिस्ट्री ऑफ इलेक्ट्रॉनिक्स एंड इंफॉर्मेशन टेक्नोलॉजी। Under the powers given to the Ministry of Electronics and Information Technology by the Information Technology Act 2000, the MeitY has issued what is known as the rules, which are known as the IT rules. And the objective of the IT rules is to set out the procedure for regulation of social media intermediaries. This is the objective of the information technology rules. Regulation of social media intermediaries, मतलब प्रश्न ये है कि सोशल मीडिया इंटरमीडियरीज किस आधार से अपने कंटेंट को रेगुलेट करते हैं, किससे उसको बैन करते हैं, किससे किसी चीज़ को फेक न्यूज़ बोलते हैं, किसी चीज़ का अकाउंट सस्पेंड करते हैं। ये अब सोशल मीडिया कंपनीज के हाथ में नहीं छोड़ा जा सकता है। It has to be taken in the hands of the government, and the government is going to give them some principles based upon which they will regulate the content coming and going out of their media platforms. Okay, in very short and precise terms, this is the objective of information technology rules. So if a question comes whether social media enterprises, social media intermediaries in India, are they governed by the government or they governed by themselves like the media in India? The answer today to that question is that after the introduction of the information technology rules, The social media enterprises in India are governed by the IT rules 2021 as amended in 2022 and 2023. Okay. Now, for example, what does the government do in 2021, 2022, 2023 rules? It says that every social media intermediary, basically what it says is every significant social media intermediary has to appoint certain officers. For example, there is going to be a chief grievance officer, then there is going to be a chief nodal officer. These officers have to be, let's say for example, there is a Twitter. Now Twitter has to appoint a person at these roles who will be directly reportable to the Ministry of Electronics and Information Technology for the activities that they are doing to regulate the content on Twitter. मतलब एक अगर मान लीजिए किसी व्यक्ति ने अपना कोई ट्वीट, किसी का ट्वीट कोई ऑफेंसिव पाके उसको रिपोर्ट अब्यूज किया है, okay, if a person is let's say asking for a report abuse of a particular activity or in Twitter, etc., then now at this point of time, if Twitter does not respond to that person's report abuse in time, MeitY will start questioning the chief grievance officer and chief nodal officer as to what have you done about the reports which have been made by people in your company. मतलब अगर आपके सामने कोई रिपोर्ट लेके आया तो अब आपको उसकी पूरी फाइल रखनी और उसकी फाइल पे आपने उनके क्या उत्तर दिए और उन रिपोर्ट्स को किस तरह सॉल्व किया. That has to be submitted to the government of India under the information technology rules. A set of compliances have to be check-boxed by every significant social media intermediary. Significant social media intermediary means media intermediary which is having what you can call a audience base of more than 50 lakh. That is the definition which is given in the information technology rules. तो मतलब मान लीजिए कोई बहुत बड़ा ट्विटर या फेसबुक या व्हाट्सएप है जिसके पास 50 लाख से ऊपर वो हो सकते हैं, मतलब people who are using it can be called a significant social media intermediary. Every significant social media intermediary has to check a box as to what are the compliances which are mentioned under IT rules that they have to report to the government now. Now here's a trick about it. If any social media intermediary fails to check box a compliance, जैसे मान लीजिए किसी social media intermediary ने अपना चीफ कंप्लायंस ऑफिसर नहीं अपॉइंट किया या चीफ ग्रीवियंस ऑफिसर नहीं अपॉइंट किया, सरकार को जवाबदेही नहीं दी, सरकार के पास फाइलें नहीं भेजी कि उन्होंने किस डिस्प्यूट में क्या डिसीजन लिया, उसकी क्या रीजनिंग है, तो द IT रूल्स से दैट for the non-performance of the compliances under the IT rules, a social media intermediary's immunity under section 79 shall be suspended. A social media intermediary's immunity under section 79 will be suspended, which basically means that any social media intermediary, if it does not agree to what the government wants it to do in terms of regulation of the content, then the government can pass an order, the MeitY can pass an order that the immunity which is enjoyed by that social media intermediary can be suspended by passing the information, suspended by the suspending of the section 79, and the FIRs can be made against the CEOs of the company. So at some point of time what had happened was, let's say for example, take a look at this. This is an example of how it started developing in the current affairs, and now it becomes important and necessary for you to understand with reference to the current affairs. Take a look at this. The government has said that the social networking platform Twitter has lost the immunity granted to intermediaries under the IT Act 2000, the government told the Delhi High Court on Monday. This was because of its failure to comply sorry, it's just acting up. So the news article basically said this, that the social media intermediaries, for example, what Twitter had done was, Twitter has in a way rejected the government's said, and for the longest time it did not appoint any chief nodal officer or chief grievance officer, and as a result of this, what the government of India, MeitY, issued a notification that the immunity which is given to Twitter under section 79 acts suspended because it has not been able to comply with the regulating guidelines under the information technology rules. Okay. So what this basically specifies is that the punishment, now this is a question for the prelims, a directly pointed question for the prelims. What is the punishment which is given in the information technology rules for non-compliance of the Information Technology Rules 2021 as amended in 2022 and 23? And the answer is that the safe harbor provision / section 79 of the Information Technology Act, the immunity which is given to social media intermediaries from criminal liability of the content which is circulating on the media shall be suspended. You know what that means? What that means is that as soon as this immunity is suspended, then for example, an organization like Twitter can, let's say if someone posts an incorrect map of India on Twitter, and that posting of incorrect map of India on Twitter is a crime under certain laws in India, then the FIR will not only be registered against a person who has posted it from his account, but also the CEO of Twitter in India, because the company does not enjoy the immunity which has been given to Twitter under section 79 of the Information Technology Act. Right? This is a part that becomes a relevant discussion under Article 19 and under Article 19(1)(a) of the Constitution with regard to freedom of speech and expression of social media intermediaries and people on social media intermediaries with relation to section 79 of the Information Technology Act. Okay, so we have taken a look at this particular aspect of the current affairs. We have given you an understanding of the Personal Data Protection Bill and the laws which are associated with the KS Puttaswamy case and the B.N. Sri Krishna committee, but also the information technology rules which have been given by the government of India, which it has amended time and again. The provisions of that you can read from the notes that we are circulating, but the important things that you would want to remember for this is section 79A, section 79 of the Information Technology Act and the relevant sections with regard to what is known as a safe harbor provision which is given under section 79, and the information technology rules which are now bringing a transformation in the self-regulated nature of social media to a government regulated one, and anyone who is not complying with these government regulations, immunity is being suspended under section 79. Though the immunity which was suspended for Twitter did not remain suspended for a very long time, it was able to of course paralyze the activities of Twitter for some time unless they had completely regained the position of what you can call making that kind of a thing happen again. Okay. All right, take it, chalo. I think it's a good time for us to take a break. We'll come back with the remaining articles. There's a lot of material that I want to dispense before the day ends today. So please come prepared, have your snacks and a little bit of a rest, and we'll begin with the next part. When we're going to discuss, I'll just number out what are the things that I want to discuss. I want to discuss disqualification of MPs, with the current case of MP from Congress who has been disqualified under the Representation of People's Act section 8. Okay, this is the first thing that I want to discuss. Then the second thing that I want to discuss is the anti-defection law, which has been heavily in news since the formation of the Maharashtra government under Eknath Shinde as a leader of the Shiv Sena, and a lot of complications happening in that regard because of the judgments which have been given by the Supreme Court. So after the break, these are the two important things that I will start up with. So I will see you on the other end. Okay, right. So welcome back, all of you. We are back online. Okay. So please just take out a pen and a notebook. I'll just give you some amount of just very simplistic notes about both of these documents that we're dealing with. Okay, we'll take a look at the data protection law, some amount of notes that you can just scribble down so that you can have some amount of understanding in terms of creating pointers about it, and also the okay. This is an article that I'm going to attach with the notes that we have to distribute you. This is a Hindu explainer page on the Information Technology Rules 2021. Okay, so I'm just going to highlight a few points. Just read them barely, and you keep a note of things as you write a certain. If you put down these points in the notebook at this point, it will come in handy for you to find them at one place where I have explained everything correspondingly. Okay, here we go. The Ministry of Information, Electronics and Information Technology, MeITI, has notified amendments to the Information Technology Intermediary Guidelines in Digital Media Ethics Code Rules 2021, which are also known as the IT Rules 2021. In June 2022, MeITI had put out a draft of an amendment and solicited feedback from the relevant stakeholders. The draft generated considerable discussion and comment on the regulation of social media in India. Okay, so this is after the news had developed that amendments were made to the Information Technology Rules 2021. Okay, so what you can take down in your notebooks is this part. This is the full name of the law, in case you want to remember it. Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021, as they are amended in 2022. As amended in 2022. Now, let me repeat the significance of these rules again. These rules are the method by which the social media in India is moving from a stage of being self-regulatory to being government regulated. Okay, so that's the point about it. This is a move by which the social media in India, the social media intermediaries in India, are moving from being self-regulated to being government regulated. Okay, so that's the point that you can take it out from here. And after that, this is the part that you can read in the given article. It compares the Information Technology Rules 2021 and the changes which have been made in these rules in 2022. Okay, this part of the article, that how is the first draft of the rules different from the most recent draft of the rules. Okay, for example, let's say the original IT rules 2021 obligated the SMIs are the social media intermediaries, to merely inform its users of the rules and regulations, privacy policy and user agreement that govern its platforms, along with the categories of content that users are prohibited from hosting, displaying, sharing, etc. on the platform. This obligation on the SMIs has now been extended to ensuring that its users are in compliance with the relevant rules of the platform. Okay. Further, SMIs are required to make reasonable efforts to prevent prohibited content being hosted on its platform by the users. Okay, just take a look at this. If, for example, we want to understand the changes which have been made in the information technology rules from 2021 to 2022, you can take a look at this paragraph which I have underlined over here. The earlier version of the information technology rules obligated the social media intermediaries to merely inform its users. It's kind of a notice, intimation of what is rules and regulations in privacy policy and user agreements. Okay, but now the rules have changed of ensuring that the users are in compliance with the relevant rules of the platform. Okay, so now users have to, in a way, make sure that not only are they aware of the rules, but they agree to the rules. Let's say, for example, if a kind of a notification has been issued by a social media intermediary that a kind of an activity, if you perform or involve yourself into a certain kind of an activity, it will be a violation of the code of conduct of the user on a social media platform. If he does not agree to that fact, then he may not be allowed to use that social media platform, right? So the focus has shifted from just making aware. Focus has shifted from mere awareness to making the users compliant. Okay, that's the first part. Second thing which has been given in the new IT rules, in case it emerges as a kind of a multiple choice question, is that the social media intermediaries have to respect all the rights accorded to the citizens under the Constitution, including in the Articles 14, 19 and 21. Okay, the social media intermediaries, SMIs, have to keep in mind the rights which are given to the citizens of India under Article 14, 19 and 21 as they are undertaking their operations. Okay, clear? This is the next part that you can remember. Okay, now these are the 2 points that you can remember in which the 2 rules have changed over the last year. Then the next part that you can take a note of, which has been introduced in the IT rules 2022, again can be asked as a question, is that the government has instituted a grievance appellate committee. The committee is styled as a 3-member council, out of which 1 member will be a government officer, while the other 2 members will be independent representatives. Users can file a complaint against the order of the grievance officer within 30 days. Importantly, the GSE is required to adopt an online dispute resolution mechanism which will make it more accessible to the users. Okay, this is a very MCQ like literature that you may want to remember at this stage. Okay, now this is what basically is one of the important points about the information technology rules, that it has instituted something which is known as a grievance appellate committee. So earlier we talked about the CGO, Chief Grievance Officer. If you have, for example, certain complaints against a social media platform or intermediary or content hosted upon it, you have to file a complaint to the social media intermediary, whose Chief Grievance Officer is supposed to take that complaint up and in a way tell you that your complaint is being acted upon, etc., etc. But now, because of the 1 year of looking at the practicality of the grievance complaint officer not working properly, the information technology rules have instituted what is known as a grievance appellate committees, GACs. grievance appellate committees, which is styled as a 3-member council, out of which 1 member be a government officer, while the other 2 members will be independent representatives. So user can file complaint against the order of the grievance officer within 30 days. Importantly, the GSE is required to adopt an online dispute resolution mechanism which will make it more accessible to the users. ठीक है, तो इसको आप थोड़ा सा याद कर लीजिए. What are the very probable things which can be asked from the information technology rules 2022 as current affairs? Okay, this is not even 1 year before the examination, and it's going to be a relevant part of the UPSC prelims examination. Okay. Yeah, so you can take a look at this article. I think this article would be sufficient for you to read anything about the IT rules. I'll be attaching this article at a portal that we are going to replace. We are going to place all the documents for your review. Okay. Here's a document similarly that I want you to read upon the personal data protection law. What is the relevance of this particular document in terms of creating a information base upon the personal data protection law? Right. Now, this is the point at which we can take a look at the history of the personal data protection law. That would be sufficient. I told you that recently a 4th draft, or let's say a 4th iteration of the data protection law in India was introduced before the parliament. The first draft of the law of the personal data protection was proposed by the Justice Shri Krishna Committee set up by the Ministry of Electronics and Information Technology. This we have covered, with the mandate of setting out a data protection law for India. The government made revisions to this draft and introduced it as a Personal Data Protection Bill 2019 in the Lok Sabha in 2019. On the same day, the Lok Sabha passed a motion to refer the PDP Bill 2019 to a joint committee of both the houses of Parliament. Due to delays caused by the pandemic, the Joint Committee on PDP Bill submitted its report on the bill after 2 years in December 2021. The report was accompanied by a new draft bill, namely the Data Protection Bill 2021, that incorporated the recommendations of the JPC. However, in August 2022, citing the report of the JPC and the extensive changes that the JPC had made to the 2019 bill, the government had withdrawn the bill. Just take a look at this. Very simply, if you want to take some notes out of it, which you feel are relevant for the prelims examination, you can take a look at it. This is what you call the journey to and fro of the Personal Data Protection Bill from the K.S. Puttaswamy judgment till 2022. Okay. If you want, you can take a screenshot. Otherwise, I'll be attaching this document anyway for you to take a look at. Right, so the 2019 bill, the government was withdrawn by the government, and the latest news in this is that the latest development in this is that the draft of the data protection law, which is known as the Digital Personal Data Protection Bill 2021, has now been made open for public comments, and the government is expected to introduce in the parliament in this budget session of 2023. It was not introduced in the budget session of 2023. It will likely be introduced in the monsoon session. Right, so just remember the name of the bill, because the name of the bill has changed so much and so often. The name of the bill that you can remember over here, which is currently the functional bill on the protection of personal data, is Digital Personal Data Protection Bill 2022. Okay, Digital Personal Data Protection Bill. This is the name of the bill. ठीक है, इसका इतना इतिहास कॉम्प्लिकेटेड हो गया है कि इस चीज़ पे क्वेश्चन बन के MCQ की तरह UPSC पूछ सकता है. तो इसको अगर आप याद कर लेंगे तो थोड़ा आसान हो जाएगा काम. Digital Personal Data Protection Bill. First it was Data Protection Bill, then it was Personal Data Protection Bill, then it was a Digital Data Protection Bill. Now it has become Digital Data Personal Protection Bill. Because of the confusion, it can be exploited as a MCQ that you can prepare. Okay. Okay, so that's the kind of thing that I would want you to take a look at simply and easily. All right, fine. So we are comfortable with this part of information technology rules, section 79 of the Information Technology Act, safe harbor provision, the Bazi.com case, the 2005 and 2012 judgments of the Delhi High Court and the Supreme Court, and the information technology rules and the penalties for information technology rules breaches, section 79 of the what you can call the information technology rules, right? I think I was showing you a set of news articles. Here, for example, I was referring to this news article. Something wrong. Yeah. You can take a look at this briefly. UP Police files an FIR against Twitter Inc. India unit over a viral video, right? So all the immunities that were enjoyed by companies like Twitter, etc., they were now lost into oblivion because of the suspension of section 79 of the Information Technology Rules, Technology Act, which had given all forms of governments the ability to strike a FIR kind of an activity against the officials of the Twitter, because the immunities was now getting lost. Right. Okay, so now the next important things that I'm trying to do is basically related to what you can call, I've already made you understand what is the nature of Article 21, which is life and personal liberty cannot be taken away of any person. No person's life and personal liberty can be taken away except by the procedure established by law. Except by the procedure established by law. Okay. Now, just a kind of a revision of Article 21. Life under Article 21 means the body of a person, and personal liberty under Article 21 means the mind of a person. Life means body and personal liberty means mind. Okay. Now, what it says is that no one can be deprived of their body or their mind except by a procedure established by law. Clear? And later on, for example, in the what you can call the A.K. Gopalan case, in the A.K. Gopalan case, 1951, Supreme Court had said that Supreme Court cannot exercise judicial review. Supreme Court cannot exercise judicial review over the procedure made by the Parliament. Supreme Court cannot exercise judicial review over the procedure made by the Parliament in pursuit of its powers to take away the life and personal liberty, of any person. to take away the life and personal liberty of any person, comma, even if it violated rules of natural justice. Okay, this was a famous judgment by the Supreme Court in which it had refused to bring the activities of the Parliament under Article 21 when it creates a law for depriving a person of his life and personal liberty, even if that law breaks down the the rules of natural justice. This is A.K. Gopalan case 1951. The A.K. Gopalan case was overturned by the Supreme Court in the famous Maneka Gandhi case, Maneka Gandhi versus Union of India, 1978, in which the Supreme Court had held that a procedure established under Article 21 must be just, fair and reasonable. Okay. A procedure established under Article 21 must be just, fair and reasonable, and if the procedure is not just, fair and reasonable, the Supreme Court can exercise judicial review. Also, the Supreme Court held that rules of natural justice, must be employed. While taking away the liberty of a person under Article 21. A very simple comparison between two landmark judgments which were given over here by the Supreme Court. One in 1951. In 1951, the judgment of the Supreme Court said in the A.K. Gopalan case that the procedure established by law is something that the Supreme Court cannot interfere in. Just please listen to what I am saying. Questions will be formed exactly in the same language. So, even if you have to memorize at this point of time, it's going to be worth it. Okay. Article 21 says life and personal liberty of any person cannot be taken away except by the procedure established by law. Supreme Court in the A.K. Gopalan 1951 case said that the procedure established by law is entirely as a concept under the control of the legislature, and therefore the Supreme Court cannot review the procedure by which a person's liberty has been taken away. On the other hand, with the due process of law, for example, as a concept which was available in the American Constitution, okay, I'll just mark it out. India had taken the concept of procedure established by law from the Japanese Constitution. Okay, and India did not take the concept of a due process of law, but which was available under the American Constitution. In the procedure established by law, there is no room for judicial review on a procedural law. In due process of law, there is room for judicial review. Okay, may not be in line with principles of natural justice may not be in line with principles of natural justice are always in line with principles of natural justice. These are very simple points which you can just memorize in context of your prelims examination to answer any kind of a one sentence question on the due process of law and procedure established by law. Okay, a very simple and categorically tabular comparison between the two concepts. Procedure established by law drawn from the Japanese constitution, due process of law present in the American constitution. India prescribes to this. No room for judicial interpretation, judicial review on a procedural law. There is room for judicial review. May not be in line with the principles of natural justice, is always in line with principle of natural justice. Let me bring out the two elements of principle of natural justice. No person shall be a judge in his own case. This is the first principle of natural justice. Second principle of natural justice is no person shall be punished without being given a right to be heard. Okay, no person shall be punished without being given a right to be heard. These are two principles of natural justice. They may not apply in the procedure established by law, but they do apply in due process of law. As a last minute point, if you want to remember how to answer questions in due process and law and procedure established by law, just memorize them. I don't think we have the time in which I will make you understand the conceptual background of it, but if you can, just draw this table and all your questions from procedure established in due process can be answered by the reference to these tables. Okay. Also keeping in mind that India has adopted it from the Japanese constitution, procedure established by law. Okay. It has not adopted the due process of law. But in the Maneka Gandhi judgment, the Supreme Court started giving interpretation that the procedure can be just, fair and reasonable, and the Supreme Court can exercise judicial review. So this is over here that the Indian constitutional thinking started moving towards the direction of judicial review under what is known as due process of law. Okay, so today India is not a strictly procedure established by law country, but it has elements of due process of law because the Maneka Gandhi case allowed the judges to interfere into interpreting certain procedural laws made by the parliament. Okay, take. Now let me just go and change the